be up momentarily. Your Honor, do you need a copy of the cover sheet from the previous plea?
Please.
You have it? I mean,
Thank you.
Your Honor, Ashley Herndon on behalf of Maurice Simmons in 21 CF 37 and 21 CF 808. The understanding today in 21 CF 37 count 1 is that he will be adjudicated guilty. He'll be assessed standard fines and costs, and he'll be sentenced to 10 years in the Department of Corrections with credit for time served. In 21 CF count 37 count 2, he will be adjudicated guilty, sentenced to 5 years DOC with credit for time served to run concurrently with count 1, and all counts in 21 CF 808. In 21 CF 808 count 1, he'll be adjudicated guilty, assessed fines and costs, 10 years Department of Corrections with 3 of the 10 served as a minimum mandatory sentence. He'll be allowed credit for time served, and this is to run concurrently between all counts and all cases. Count 2 in 21 CF 808 was previously no cost by the state.
Very good. State in agreement?
That was the plea hearing that was under trial.
Very good. So based upon that, the court will provide the sentencing for today. So just to repeat for the record, as to count 1 on 21 CF 37, there will be an adjudication of guilt, actually adjudication of guilt on all three cases. There will be 10 years Department of Corrections with credit for time served. 21 CF 37 count 2, again adjudication of guilt, 5 years DOC with credit for time served, concurrent with count 1 and all counts in 21 CF 808. And in 21 CF 808 count 1, adjudication of guilt, 10 years Department of Corrections with 3 of the 10 years as a minimum mandatory sentence, credit for time served. Again, it runs concurrent with all counts in 21 CF 37 and count 2 of 21 CF 808. Again, all these will be served concurrently, all these cases, for a total of 10 years. And you'll have the standard fees and costs that are contained in this. Anything else we need to address?
That's all, Your Honor.
Okay.
Is his probation revoked and terminated?
Oh,
Yes.
yes.
It actually doesn't say that, but yes. I believe that states in agreement with that, right?
Yes, sir.
Okay. Very good.
Thank you.
Thank you very much.
That's all I have, Your Honor. If I may be excused, sir.
You may. Thank you. Have a nice day. Mr. Patel.
Good morning, Judge.
Good morning.
Jake Patel and Tim Shaw on behalf of Bradley Dunham. Judge, he's here with the support of his parents. Mr. Dunham was a juvenile at the time of the offense occurred. He was since charged as an adult. This is 21 CF 1573. At this time, Mr. Dunham changes his previously entered plea of not guilty and enters a plea of no contest open to the court, and the defendant requests a sentencing hearing. The defense anticipates calling Dr. Randy McDonald, consistent with her evaluation of Mr. Dunham, and speaking to Dr. McDonald's office. Her first available date, with our first available date, is March 21st, so we'd ask that that day be the sentencing date.
I assume we're going to do a PSI?
Yes,
correct?
sir.
So I just want to make sure we've got enough time to get that done. Probation?
What was the sentencing date?
They were requesting March 21st. Is the state okay with March 21st?
The state can make that happen, Your Honor, yes.
We'll
Okay.
be ready. We'll have
Okay.
it done.
Very good. Do we have, is that a miscellaneous day?
Yes, Your Honor. There's
And is that open? I mean, how long do you anticipate? At least an hour? At least an hour.
At least an hour.
Hour, maybe more, hour, closer to 2 maybe. So I just want to make sure we've got enough time. So, okay. March 21st, 2:30.
May I approach?
You may. Thank you. Okay. Mr. Dunham, would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
Okay. So, I've just been handed a plea and sentencing agreement, Mr. Dunham, that contains your signature. And your attorney also stated for the record the terms of the plea agreement. It's a plea agreement that's open to the court. So they call it various things, plea to the court, etc. So essentially, are we pleading no contest? Is there an agreed upon adjudication of guilt?
There's not, Judge.
Okay, so all that's open at this point. Okay.
Mr. Dunham understands everything is up to the court.
Okay. So you understand that, you know, you're entering a no contest plea, which is what I often say is kind of the half brother to a guilty plea. It's not, you're not pleading guilty, but you're basically saying that you believe the state can prove their case. Is that your understanding of the no contest plea in the state?
And yes, Your Honor, and just for the record, Your Honor, he is charged with 25 third-degree felonies, which makes his minimum guidelines 95.85 months, a maximum of 125 years, and these charges will require a sex offender designation regardless of adjudication or sentence.
And have you gone over, has that information been presented to you that was just provided by the state?
Yes, sir.
Okay. So you understand that obviously this is the potential sentence is significant. And that's, I guess, the main thing that I want you to understand is that your opportunity to be able to contest these is now. By entering into this plea agreement, you have an absolute right to argue about the sentence, but not the underlying plea that you're entering into here today. Do you understand that?
Yes, sir.
So by entering into this plea here today, other than the sentencing portion of it, this will be a final adjudication of your case. Do you understand that?
Yes, sir.
So you're waiving the right, some very valuable legal rights. I'm sure you've gone over it in detail. I just want to make sure and put it on the record. You're waiving the right to go to a trial, the right to contest these matters, the right to confront witnesses, the right to have the state prove their case. You have no obligation to prove anything in this. The state has an obligation to prove beyond a reasonable doubt that you've done these things. Do you understand that? You're waiving all those rights. Do you believe it's in your best interest to do so?
Yes, sir.
Did anybody threaten or coerce you to get you to enter into this plea?
No, sir.
Obviously, you've got two very experienced attorneys on either side of you. And I just want to make sure that you've consulted in depth with them to go over not only what's in the plea and sentencing agreement, to really go over what this plea and sentencing agreement means. You feel like you've had all your legal questions answered regarding this plea agreement?
Yes, sir.
Okay. Do you have any further questions?
No, sir.
Okay, and there is a factual basis for this plea?
Yes, Judge.
Very good. Based upon that testimony here today, the court will accept your plea of no contest on all 25 counts of 2020 CF 1113, and the court will return on March 21st. We'll consider the PSI as well as all evidence that can be presented for or against by the state and the defense on March 21st.
Judge, it appears there might be Scrivener's error on the case number. It is 21 CF 1573.
What's going to say that? Yeah, that we definitely want to get that straight.
And I'm sorry, Your Honor, what time was that set for?
2:30. This is in the afternoon.
Thank you.
Oh, no, it's right here, Judge.
What's that?
It's right here. I heard the court say a 2020 case number. Is the body?
Okay, but this one says 2020 1113.
I'm sorry about that.
That's all right. That's all right. You're right at the top. It does, but I was reading from the one. Very good. So, to correct that, this is on case number 2021 CF 1573.
Thank you, Judge.
Anything further?
Nothing. We'll be back before the court in a couple months on the 21st at 2:30.
Thank you very much.
Thank you, Judge. May I be excused?
No.
Thank you.
Mr. Shaw, you've got a couple of them.
I do, Your Honor. Are you ready?
I'm ready.
Judge, the first one I have is Gary Blaine Fagan, 22 CF 2129. Here. Jerry, Judge, on Mr. Fagan's case, I've spoken with Mr. Rogers this morning. Two things. One, the lab reports are not back yet as to count one. However,
Let me just ask this, because I'm seeing this a lot on this. The hearing is titled Status Conference. Why are we getting status conferences? Usually we used to get status conferences when there were like competency hearings. It's like a return. This is just like,
Judge, well,
so tell me, when it says status, somebody needs to tell me what we're here about, because I'm going through the file and I'm like trying to figure it out. So I'm sorry.
Judge, my recollection is we had left it set back in December in hopes of getting the case resolved. The court, instead of, at that hearing, instead of going a full continuance, I think the court said put it on today just to see if we could.
What's the underlying? It's the VOP?
No, Your Honor, it's all new law violations.
All new law.
Okay. Yeah, 3 counts. But in addition to the labs not being back on count 1, the state has made an offer, and it would be misdemeanors, Judge, that if the court would, if we decide to accept that, we'll send in a written plea agreement for the court if that's acceptable to the court to misdemeanor.
So we want to just go ahead and put him back on pretrial?
Correct, Judge.
Okay. So we'll come back on our February pretrial. We'll continue this pretrial on 13th.
9 a.m.
We should have 2 pretrials because we have an inmate and a non-inmate. And I only have one. The clerk clarify this? It's incorrect. Usually we do the first day as usually we've done Monday and Wednesday, but Monday is not. So that will be the February 13th, usually we usually do non-inmates first and then inmates on the second. Okay, so February 15th will be inmates, pre-trial. And February 13th will be non-inmates. Okay, so this will be February 13th.
Thank you, Judge.
Okay, thank you.
Judge, next case is Jerry Lee Hollingsworth. Judge, as to, in Mr. Hollingsworth's case is 22 CF 1975, status conference as well, Judge. Same thing, we had hoped to get it resolved. We have not resolved it. There's one bit of discovery that I'm wanting to take a look at. If
You want to do the same thing, come
result,
back at pre-trial?
213.
Okay, 213 on pre-trial.
Thank you, Judge. And lastly, Judge, I have Kevin King, 22 CF 770. State has made an offer. I met with Mr. King yesterday. We have to speak with an immigration attorney with regard to the consequences of the plea offer. I anticipate making a counteroffer to the state after speaking with immigration. Hopefully we can get it resolved. If not, we do have deposition set for late this month, I think the 24th maybe. So cases moving forward, if we can put it on 213, I'd appreciate it.
We'll continue to 213. State okay with that?
Yes, Your Honor.
I'm assuming state will jump up if they're not when I'm going. They're not meaning to exclude you.
That's fine, Judge, thank you.
Okay.
Thank you, Judge, and that's all I
I think
have.
that's all you got. Thank you, Mr. Thanks, Shaw. Mr. Dees? Good morning, Mr. Dees.
All right, Kyrie Evans. Marjolee Cordial, Robert Dees on behalf of Mr. Evans, who's before the board on the violation of probation, case 20 CF 3067 here, Judge. The state has made an offer this morning to evaluate home for mental health court.
What is the case number?
Your Honor, it's
I've got 22 CF 183 is what I've got.
Yes, Your Honor.
Is that right?
Yes, Your Honor, that's the case.
A violation of probation.
It is a violation.
Okay,
That
I'm
is
sorry.
true. Just on the primary docket number on the score sheet, just to bring it to the clerk's attention, that may have 20 CF 3067, so I'm not sure where that number's coming from.
That might be incorrect, Mr. Dees, I apologize.
That's okay. But anyway, Judge, at this time, the state would like to send him to the health court, which I think would be a good resolution for him. If we could pass it to your nearest violation of probation, we'd like to bring it back in and see if he's been accepted in the mental health court. The alternative would be 11 months and 29 days in the county jail setting.
So we've got a miscellaneous on the 17th. Is that too soon, or do you want to come back on the 14th of February?
Judge, I'm unsure if Miss Adams is going to be able to meet with him before the 17th. I can ask her.
What's your next date after that, Judge?
February 14th.
Yeah, let's leave it on a short docket, and if we can't get it, we'll move it on.
Yeah, let's try and, if not, he's holding them up. So let's try and get it on January 17th in the morning. And then if we can't, we can just move it. That's not a problem.
That's great.
Okay.
Thank you, Judge. Have a good day.
Okay, thank you very much. Ms. Dudley.
This is Todd Adams, 22 CF 1584.
Who is this?
Todd Adams.
Todd Adams, okay.
We're here on a motion to reduce modifier set bonds.
Okay.
Mr. Adams is originally out on the bond of $138,500 bond. He received a failure to appear for felony arraignment, and a no bond KP was issued. Mr. Adams resides in Mississippi. He has 4 children that he helps take care of. Legally, he's entitled to a reasonable bond, even on the failure to appear. We're asking that a reasonable bond be set in this matter. And in addition, we're asking that he was arrested on a additional count that the state added into the information, the original information, and it's in this case, and he was given a $20,000 bond. We would ask that that bond be reduced to a lesser bond so that he can make bond in this matter.
Yeah, I'm not following. I lost you there.
So he has 2 different things. He has a failure to appear with a no bond.
Gotcha.
And then when the state filed the information in this case,
Right.
they issued a capias for another count. So that count is a separate bond of $20,000 that he has right now.
So he's got a no bond on the failure to appear, and then what bond does he have? He has just 20,000? That's no.
20,000 on the other charge. So what happens?
What's the other charge?
It's a trafficking of hydrocodone.
Okay, gotcha.
So it's the last.
And then what's the other bond that's set?
The other bond?
Well, the bond. Does he have any other bonds for the other charges?
No, we have a no bond on those for the failure to appear.
Okay. What was the bond prior to the
Yes, sir.
failure to appear?
$138,500.
Okay, that's what I thought. So you're asking for a bond? What bond are you requesting?
We're asking for a reasonable cash professional bond on the failure to appear, and then we're asking for a $10,000 bond on the trafficking and hydrocodone. It's weird because it's the same case, but they're kind of separate because that charge wasn't on the docket when he got the failure to appear.
Dave?
So, yes, Your Honor. So in addition to several charges to include battery on a law enforcement officer and a simple possession of a controlled substance, he had counts 7, which was trafficking in methamphetamine. The count 8 was added as a direct issue KPS. That is the trafficking in hydrocodone or codeine and hydrocodone. So he presently has 2 different charges for 2 different drugs with a trafficking weight, Your Honor, when he failed to appear. It's my understanding from looking at benchmark that he had to be brought here from Mississippi. It was my understanding that he is a resident of the state of Mississippi. It's the state's contention that in addition to the serious nature of the charges, he is a flight risk, so the state is requesting the bond remain at no bond on the failure to
So you disagree with the defense's contention that even on failure to appear, he's legally entitled to a bond?
Yes. I do disagree with that.
And I'm
Didn't I
sorry.
hear you say that?
Yes, that's the law.
I'm trying to clarify that,
absolutely.
and that's obviously important.
And I have case law, Your Honor, including a case where it talks about, Harvey State 238 Southern 3rd 353. I get a court copy. Well, it talks about 2 failure to appears.
Okay.
Even when 2 failure to appears, the defendant is still entitled to a bond unless the state shows, well, one, they're saying it's a flight risk. They have to show that there's no legal means of pretrial release to protect the public or his appearance in court. They haven't shown that. Just to say that he's a flight risk is not enough. He's still entitled to a bond on a failure to appear. And the case law is very clear about that. Which is why I cited in the motion. He is legally entitled to a bond on that charge. If they prove the item under pretrial detention, as they can, if they choose to try to prove that, and they can make that, get over that hump, then he wouldn't be entitled to a bond, or the court can then hold him without bond. But to simply hold him without bond is not appropriate based on the laws in the state of Florida. He is entitled to a bond unless the state can show, as any other bond hearing, that he's a flight risk, there's no reasonable means of pretrial release to protect the public, or he's a danger, or whatever else they can find up under that statute if they prove that. They haven't proven that. The fact that he lives in Mississippi does not in itself make him a flight risk.
Ms. Sharp?
Your Honor, there is a motion and an order for the forfeiture of the bond from the bond company that states that when on the failure to appear, when they looked for him, they were unable to find him. They went to the residence that he was supposed to be staying at, and he was not at that residence, and his family member that stayed there said that they had not seen him. And again, he was in the state of Mississippi when he had to be brought back here, Your Honor. He is a flight risk. I do have concerns that he is not going to show back up to court if he's released out on bond. And clearly, even a GPS monitor is not going to keep him from not failing to appear again, as it appears that he's just going to leave and go to a different state.
Ms. Dudley?
Yeah, he was on probation in Mississippi. He was reported to probation in Mississippi. And he'll be on probation when he goes back to Mississippi. He was brought over here from that probation violation based on these charges, and he will go back over there and be on probation.
Okay. So the court's going to reinstitute the $138,500 on the underlying bond, the $20,000, and the court's going to issue a $50,000 failure to appear bond.
So are you saying, are you upping the bond on the trafficking?
I'm instituting a separate bond on the failure to appear.
So it's failure to appear $50,000 and you're keeping the bond the same on the trafficking case?
Correct.
Just want to clarify the right numbers, that's all.
No, that's what I'm doing.
Listen.
Okay.
You know, next case? Your Honor, next case I have, I believe it's Caitlin Brown, Your Honor. I have filed a motion to compel, there's a waiver on file. At this point, I believe the motion is moved. The state has provided me all the items listed in number 5, and then they have been told by our patrol there is no video. So I'll find out if there is a video and we'll do it then.
Okay, very good. So we'll just,
Move that
the
from
motion would compel, I'll just say it's withdrawn.
Yes, sir. The next case I have is Jadero Sampson. Mr. Sampson is present. Your Honor, if I may approach?
You may. Thank you.
Mr. Sampson is here in 21 CF 307 and 21 CF 614. And he's going to withdraw his plea being not guilty and a plea of no contest in 21 CF 614 to count 3. It will be a lesser charge of conspiracy to commit extortion. It will be a third degree felony level 5. The state will dismiss all other counts in that case number, as well as all the charges.
Hold on a second. Hold
Sure.
on. I'm sorry. Go ahead.
Yes, sir. As well as all the charges in 21 CF 407. He will be sentenced as follows: withholding adjudication, 36 months probation. He may apply for early termination after 24 months. All requirements are complete. 515 in court costs, and no contact with any witnesses or victims in this case.
The attorney's approach.
Yes, sir.
Mr. Sampson, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth to help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement, and I see that those same terms are contained in a written plea and sentencing agreement that has your signature on it.
Yes, sir.
Is that your understanding of what the plea agreement is, and are you in agreement with that?
Yes, sir.
It's important that I want to make sure you understand you've gone over this plea agreement with your attorney, make sure you had all your legal questions answered about it.
Yes, sir.
Because you're waiving some valuable legal rights by entering into this plea. The right to go to a trial, the right to contest, it affects your right to appeal, and a number of rights. You're waiving those so that you can have a final adjudication of this case. Is that what you want to do here?
Yes, sir.
You believe it's in your best interest?
Yes, sir.
And nobody threatened or forced you to get you to enter into this plea?
No, sir.
You believe it's in your best interest to do so?
Yes, sir.
You've had all your legal questions answered by your attorney?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea. As to case number 21 CF 307, the court will dismiss all charges, correct? No process on those?
That's correct, Your Honor.
And then on 21 CF 614, all charges are going to be dismissed except for count 1, in which there's a plea of no contest to the lesser included charge of conspiracy to commit extortion, which is F3, L5, and there'll be on that count withhold of adjudication, 36 months probation, and the defendant may apply for early termination after 24 months if all requirements are met. Importantly, Mr. Sampson, no contact with any witnesses or victims. We identified those.
Your Honor, we can provide that information to probation parole if the court wishes. We'll just give them the
I
list.
just want to make sure it's clear. I don't want to have any, oh, I didn't realize that, because everyone takes these no contact requirements very seriously.
Yes,
And that means, I always tell people that no contact is one-sided. That means even if they walk up to you in a friendly manner and, want to chat with you or call you on the phone, they're not in violation. But you are. So you got to stay away from them. Even if they approach you in a friendly, you got to stay away. You got to turn around and walk away.
Yes, sir.
You got to hang up the phone if they try and call you. And don't communicate.
Yes, sir.
Okay.
Your Honor, there is one thing. When the court announced the plea, Your Honor, is to the original count 3, and it's a lesser included.
Can the court announce the lesser in count 1 and lesser in count 3?
Because the way the information is written, that particular count is count 3, it's not count 1. So I just wanted to clarify that. So count 1.
Did I say count 1?
Yes, sir.
Okay.
It's a single
It says
count.
count 3 here and I misread it. Thank you for clarifying that.
Yes, ma'am, I can give you the statute number for that. It should be 83605.
And it's the defense and agreement on the score sheet.
Yes, sir.
Okay. Very good. Anything else?
Yes, sir.
Thank you very much.
No, that's all, sir.
Ms. Dudley, on the Brown case, I think she said that
Just remove the
motion
docket.
was withdrawn.
It should be on the pretrial already. It's not.
Okay, thank you. That's a good point.
It'll be on.
Yes.
Okay.
Thank you.
Thank you, Madam Clerk. That was fine. That's not mine. Okay. So I think that's all the private counsel that we have here today. Mr. Harper, you want to do yours?
Yes, sir. I have couple inmates as well as one out in custody that I haven't seen. Anthony Fannin. See from my inmates, Judge.
Your Honor, I'm still out of custody. Would it be good for me to do them first? I'm trying to.
That's fine. Whatever is most efficient. We're glad to. You want to go ahead and call it, Mr. Medina?
You mind if I call it one, Your Honor?
Yeah. I mean, I'm trying to catch up here.
Could I call Paris A. Brown? Your Honor, I'm providing the state signed DOP agreement for resolving his misdemeanor DOP that has been signed by him and me, and we've worked it out with the state. Under this violation of probation agreement, in instance, Your Honor, there was a tolling based on the tolling. We were able to enter this agreement for an adjudication of guilt. It's all on misdemeanor DOPs. Reinstate and modify supervision to add 90 days concurrent probation, complete existing requirements, $100 VOP fee times 2 because there are 2 cases, a total of 250 public defender fees, and it's just on misdemeanor, so we don't have a score sheet, Your Honor.
Okay.
Thank you. May I approach, Your Honor?
You may. Mr. Brown, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor, I do.
Okay, so you heard your attorney state the terms of the plea agreement. There'll be a reinstate and modify probation or supervision to add 90 days probation, concurrent probation, completing the existing requirements, and then some additional fees and costs. Is that your understanding of what the plea agreement is, and are you in agreement?
Yes, Your Honor.
Okay, and you understand that by entering this, you're waiving the right to contest this. This will be a final adjudication, and you'll be waiving the right to go to a trial. Do you understand that?
Yes, Your Honor.
Okay, and you've had all your legal questions answered of this?
Just about, Your Honor, yes.
Just about? Do you have any further legal questions you need?
No, Your Honor.
Okay, very good. Based upon that, the court will accept your plea. It'll be an adjudication of guilt, reinstate, and modify supervision to add 90 days concurrent probation and the fees and costs contained in the agreement. Thank you very much.
Thank you, Your Honor.
Stay in good contact with probation, okay? Go talk to them now.
Yes, Your Honor.
Thank you, Your Honor.
Thank you, Mr. Medina.
Your Honor, next is out of custody with an agreement is Ray C. Callan Jr. Mr. Callan is case number 22 CF 492.
Okay.
And he signed an agreement that contains terms worked out with the state. I do need to provide it to the state to sign, Your Honor, to review and sign. Your Honor, under this agreement, Mr. Callan, who was previously adjudicated guilty on a misdemeanor, he would be reinstated and modified in his supervision to add substance abuse evaluation within 30 days, with any recommended treatment commenced within 60 days. There would be $100 VOP fee and $150 public defender fees. May I approach, Your Honor?
You may. Thank you. And Mr. Callan, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
I've just been handed up a probation plea agreement, violation of probation plea agreement. With your signature on it, you just heard the terms of your attorney. You can put your hand up. You heard your attorney state the terms of it. Reinstate, modify to add substance abuse evaluation. It's got to be done within 30 days, and then you got to follow any recommended treatment. You understand all that?
Yes, sir.
You gone over it with your attorney. Make sure you understand what this new agreement means.
Yes, sir.
You understand that by entering into this, you're waiving the right to contest the violation. You're agreeing to, and this will be a final adjudication of this violation of probation.
Yes, sir.
Okay. Do you have any other legal questions that you need to ask of your attorney?
No, sir.
You believe it's in your best interest to enter into this?
Yes, sir.
Okay. Based upon that, testament states an agreement. Yes? Yes, states an agreement. Yes. Who's in there? Yeah?
Yes, sorry.
Okay. Thank you, Ms. Sharp.
I apologize.
It's all right. So based upon that, the court will accept the plea, the violation of probation plea agreement. There'll be, previously it was adjudicated, defendant was adjudicated guilty, reinstate and modify probation supervision to add substance abuse evaluation. It's got to be within the next 30 days and then follow recommendation. Then you've got the additional fees and costs. Any questions?
No, sir.
Thank you very much.
Your Honor, I had one more out of custody that I talked to. If I may call Ernest A. Merritt the fourth. Mr. Merritt has two misdemeanor BOP cases. Two BOP cases. They each have a felony, and one of them has two misdemeanors as well. 22 CF 2907 and 20 CF 764. Your Honor, I've informed him of the state's position. He has a 90-day concurrent jail offer that would allow him to keep his not having a felony record. He wants to consider that and talk it over with his family. So I'm asking for a continuance. He also would have to make work arrangements. He represents that he's gainfully employed and wants to hold on to his job. So could we have a short continuance? Could we do a month continuance?
Sure.
Yeah, that's fine with the state.
Okay. So we'll come back on February 14th, miscellaneous docket.
Thank you, Your Honor.
At 9 a.m.
Thank you, Your Honor. Call me if you have any questions. Thank you, Your Honor. That's all my out of custody that's spoken with.
Okay, very good. You ready to go now, Mr. Harper, or Mr. Gates, you want to do yours?
Yes, Your Honor. If I can
Okay.
take my one out of custody, I've got
Sure.
Docket, Your Honor. It'll be Christopher Enzi. I made notes here that Mr. Enzi should be number 20 on the docket. The first
Thank
number
you.
20 on the docket.
The first, yeah.
Your Honor, we have a plea agreement filed in Mr. Hensley's case. It'll be a plea to lesser included offenses in count 1 of driving on a license suspended second conviction, and as charged in count 2 of leaving the scene with property damage. Mr. Enzi will be adjudicated guilty on all counts based on 6 months of probation concurrent between count 1 and 2, 274 costs, 150 public defender fee. We'd ask the court to waive the cost of supervision, 24 hours of community service work, reserve restitution for 60 days based upon my conversation with the state. I explained to Mr. Enzi that meant that basically we have 60 days, but during the term of supervision, they have up to order restitution in this case. And then he asked, and I didn't have it written down, if the court would allow him to purchase his community service work hours at the lowest permissible rate.
State's great, Your Honor.
Okay. State's in agreement, so the court will go along with this.
Okay.
Is that in there, the tail? Yeah. Mr. Hensley, would you please raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Yes, sir. You heard, you put your hand up. You heard your attorney state the terms of your plea agreement, and that's also committed to a writing as well. Have you gone over this plea agreement with your attorney to make sure you understand all the legal ramifications of this?
Yes, sir.
Importantly, you're waiving some valuable legal rights. You've heard me say it. Right to go to a trial to contest all this. You understand?
Yes, sir.
This will be a final resolution of your case. I believe it's in your best interest to do so.
I do.
You've had all your legal question answered by your attorney. You're satisfied with your legal representation?
Yes, sir.
Very good. Based upon that, the court will accept your plea agreement. There'll be an adjudication of guilt on the, there'll be a lesser included on the driving on a suspended second conviction, and then as charged in the leaving the scene. You'll have 6 months of probation on each of those counts. They'll be concurrent, they'll run together, not going to stack on top of each other. Various court costs and fees that are outlined in the plea agreement. We will waive cost of supervision, and the defendant may purchase the community service hours at the lowest reimbursable rate, which I don't know what it is. The thing is $10. $10 now. Okay. Anything from the state?
No, Your Honor, thank you.
Okay. Did we get a score sheet on that?
Misdemeanor, all right.
Misdemeanor?
No score sheet.
I just make Your Honor, take it in your fingerprints.
Thank you, Mr. Gill.
Thank you, Your Honor.
Is that your only out of custody?
Yes, Your Honor.
Okay, why don't we, there are a few folks that are here that do not have attorneys. Let's go ahead and do those, and then we'll focus on the We'll do the out of custody non-attorneys, and we'll go the rest. Okay. Miss Bridget Handsaw. Who's got Miss Handsaw's case? State.
I'm sorry.
Bridget Handsaw. She appears not to be here. And I was just wondering.
State request a case, Your Honor.
Court will issue a case with no bond. Casey Sally, will come forward to the podium, ma'am. Would the state go ahead and announce this case? 19 CF 3386. So this is a violation of probation, Ms. Sally. You do have a right in this, because it's a new charge essentially. The violation is you have a right to have an attorney appointed. You wish to have an attorney appointed?
Yes, sir.
Okay. So what I'm going to do, I'm going to appoint the public defender. I'm going to enter a denial on your behalf. That will preserve your rights so you get a chance to meet with your attorney. And then we'll come back maybe on probably the 14th of February. 17th probably too quick for you, Mr.
Yes, Your Honor, and just so the court's aware, the recommendation in this case was if Ms. Sally can pay out or provide proof of payment and the community service work to dismiss the VOP.
That's accurate.
Okay, why don't we, let me just ask you this. Say that again?
If Ms. Sally can provide proof of paying her outstanding court costs and completion of the community service work, the VOP would be dismissed.
Okay. So what we can do here, and we're trying to work with you, I mean, these are technical violations. You obviously have done the other things in your probation. Do you think in the next 30 days or thereabouts that you can do those two things?
I can try to,
What we can do is I can continue this. So you've been charged with this violation.
Yes, sir.
And if you complete those things, they'll be dismissed. You won't have a violation because the violation is just another thing on your record that doesn't.
Yes, sir.
It has the chance for negative results.
Yes, sir.
So
I believe that I probably can.
why don't we come back on February 21st? We're going to continue to February 21st. And do you not want me to appoint you at this time?
It'll save her about $150.
Well, I'm not gonna appoint the public defender right now. You kind of know what the situation is.
Yes, sir.
So if the state would make a note that if she pays everything, it'll be dismissed. So remind me of it when it comes up, and so.
And just to be clear, Your Honor, I think so there's payment, there's also community service.
Right.
As well.
Yeah, I would read those over on my paper today, right? So.
Okay. So you've got about a month and a half to get these things done, but
Yes, sir.
then you get past this. I mean, you worked hard to try and get all this stuff, and I know there's a lot of costs and fees and all that stuff. It's not always easy to do, but
Yes, sir.
the court's willing to work with you, but just go on, let's get this done so you can get it, get this off your back, okay?
Yes, sir.
Okay. February 21st, 9 a.m.
Okay.
Okay, thank you. That's the only one I have. I have one out of I've got a couple other non-inmates that are on the docket. Mr. Gates, you've got Robert Taylor.
Yes, sir.
And Mr. Medina also has another one too, Mr. Anderson. You want to try and do those?
Mr. Taylor is an inmate, Your Honor.
Okay. It doesn't show up as an inmate on mine.
Yes, sir.
Okay, that's all right. Okay. You want to do Mr. Harper? You want to do yours?
Right, we're ready for
Mr. Harper. Now, it's Fanny. What about Anthony Fanny?
So he's out of custody. I was appointed to this case, I believe, last week. He's got a new law violation set for February 13th.
The court last month issued an ROR bond on the basis of Mr. Fannin being in the hospital after a suicide attempt at the jail. I don't know that we have an update on his status.
Your Honor, can we approach it briefly?
You may.
Your Honor, it was just
Anthony Fannin until, do you want to do it until just the 17th? You need a little more time, February 4th, 17th?
17th will be fine.
Okay, so we'll continue this till January 17th at 9 a.m. Okay. you announce this, Mr. Harper?
Judge Rudy Harper on behalf of Samantha Frazier, she's before the court on 22 CF 760 for a violation of probation. She was just signing a plea agreement where she'll admit the violation. It'll be a modification of her supervision to maintain the withhold. The first 3 months of her supervision will be community control, and she'll serve out the balance of her supervision, be assessed the applicable fees, complete the outstanding requirements. An additional requirement is 12.1 months Department of Corrections, but that will be suspended. If I'm your first judge, the state is advised that they'll be following this portion later.
That's accurate, Your Honor. I've got it drawn up. I can represent that I'm saying 31.6 is the score.
Okay. You're okay with the score sheet?
Yes, sir.
Okay. Ms. Frazier, I think you said Amanda. I think is it Samantha?
Samantha.
Samantha. Samantha Frazier. Ma'am, would you please raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God. Yes?
Yes.
Okay. Speak loudly in there so we can make sure.
Yes.
Okay, you can put your hand down. I just need to ask you a few questions, make sure you understand this plea agreement, make sure you're in agreement, okay? So you heard your attorney state the terms of the plea agreement, and it's contained in this plea and sentencing agreement, which you have signed on the back, right?
Yes.
Have you gone over this with your attorney and made sure you got all your questions answered about it?
Yes.
And you understand that by entering into this plea agreement, that you're waiving the right to go to a trial, and this will be a final adjudication of this violation of probation?
Yes.
And you understand that you're modifying the probation. There'll be 3 months of community control, and you're also getting was the 12.1 months DOC, was that previously ordered and suspended, or that's a new part of this?
Yes, sir. That's a new condition.
New term, Your Honor.
Okay. So, the one thing I think I want to make sure you understand. First of all, we want you to be successful on this probation. But you're walking down the wrong road right now. You've got 3 months of a higher level of supervision, this community control. You're going to have to stay in good contact. I don't like the term community control. You know, I like the better term. It's called house arrest.
Yes.
That's what community control is, right?
Yes.
House arrest. Do you understand that?
Yes.
Now, the way it works, I'm sure you figured this out. Generally, when you get charged with these things, you start out with probation. Then, if you then mess up, it's community control, and then incarceration, DOC, right?
Yes.
You get that?
Yes.
Probation. You're now at community control. Okay.
Yes.
You got a 12-month suspended sentence.
Yes.
You hear what I'm saying?
Yes.
You got to get this right, because the next step they're going to pull this and commit you on the suspended sentence if you violate it.
Yes.
So I need you day by day. You need to stay in good contact with your probation officer and fight through this and get it done, or else you're going to go to DOC. Okay, it's not what we want, but that's where it's heading. If you don't get it, I'm just trying to be honest with you. Okay? You think you can do it, and you can be successful, we want you to.
Yes.
The most important thing you do is to stay in good contact with your probation officer.
Yes.
You do that, you're 90% of the way there.
Right.
They'll work with you. Okay?
Mm-hmm.
And you also got to abide by the rules of this community control. Okay. So you understand, you believe this is in your best interest to enter into this plea agreement, even with this suspended sentence?
Yeah.
Okay. And you've had all your legal questions answered from your attorney? You understand what's going on?
Yes, sir.
Do you have any further questions here today?
No, sir.
Okay. Based upon that testimony, the court will accept the plea agreement. There'll be a modification of the probation, maintain the withhold. There'll be 3 months of community control. And the remaining balance of supervision, you've got to make sure and make the payments. That's a big part of this, unfortunately. And the 12.1 months Department of Corrections suspended sentence has been added. Okay. Very good. Mr. Harper, anything?
Yes, sir. Just one additional point. I apologize for not addressing it earlier. This is both for the court and Madam Clerk. There was a motion to withdraw a plea. We're withdrawing that at this time.
I'm sorry, say that again?
There was a previous motion to withdraw a plea. We're withdrawing that at that time.
At this time. Is that correct, ma'am?
Yes.
And you've gone over that and talked with your attorney about that?
Yes.
Okay. And the cost of supervision is waived. If you'll just add that in there. Did you have a question, ma'am? Did you have a question?
No, sir.
Okay. I thought you were leaning over like you wanted to say something. Thank you. Thank you very much, ma'am. Mr. Harper.
Judge, this is Keel. He's before the courts on 22 CF 464. It's not on the docket, but we're also addressing, I believe, 21 CF 2521. This is a motion for bond. Just some context, Judge. We had continued this motion previously. One, because we had done some depositions, and subsequent to those depositions, we determined that there was a video that was outstanding, that was addressed by the deponent, that we believe was pertinent. As of this morning, we've not been able to receive that video. The state is inquiring, still trying to locate it, because it's at the facility. It's basically a video that was provided by or in the custody of a bank, and we're trying to obtain that video. We have not received it yet, and the state has not either. We believe that's relevant with respect to both the defense and as well as for the purposes of these bond hearings, but we have not received it as of this date. Notwithstanding that, Mr. Keel is asking to proceed forward as to his bond. Essentially, we're asking to reinstate the previously imposed bonds. On one case, it was $2,000 cash, $2,000 signature, and the other was an ROR. Your Honor, with respect to his bond conditions, he did have a GPS monitor at the lowest permissible daily rate. He is asking if the court is concerned about his ability to track his whereabouts, that the court can reinstate that as well. Essentially, Judge, we're asking for the option of Mr. Keel.
Give me some history on the bond.
To be fair, it's somewhat convoluted, Judge. He did have...
yeah, that's why I'm asking you to help me clarify.
Yes, sir. He did have an additional charge that was dismissed. There was a battery charge that ended up being dismissed. He has this fraud case. He also has a burglary to a dwelling case.
So was the no bond a result of a new law charge, an additional charge while he was out on bond?
What happened is that there was an issue with respect to his GPS monitor. And Judge Polson at the time issued an order revoking his bond because of that issue. He was then subsequently arrested.
What was the issue with the GPS monitor?
I believe it had to do with the charging of it. It wasn't charging overnight. Mr. Keel advises that he had been in contact with pretrial supervision, expressing some concerns about the ability of the unit to charge overnight. And it's his assertion that it was not a willful violation, as the device wasn't able to retain a charge. In the interim, he did have a new law violation with Mr. Gates that's currently being held as a felony petty theft. What I would like to stress to the court is that none of these offenses are violent in nature, and that he's asking for reinstatement of his previous bond so that he can pursue defense on the outside.
Just Mr. Gates. Just for clarity, Your Honor, we've kind of piggybacked 22 CF 2076 on this as well. This actually occurred prior to his last arrest, which is why this case actually didn't revoke the bonds. It was the issue of the GPS that revoked the bonds. Mr. Keel has asked the court to look at the warrant that was set by Judge Brown that had a $500 signature bond. The first appearance judge decided to make a $5,000 cash or professional bond. Mr. Gill was just asked if the board's inclined to grant the motion on Mr. Harper's case is if he would modify this to a signature bond as set by the warrant judge.
Who's arguing this case?
And this is my case, Your Honor. So, Your Honor, again, I think Mr. Harper's correct. It is a little bit convoluted, but I think his recitation of what has occurred is correct. I have no problem if we want to leave Mr. Keel on for next week as a status. I do believe that the employee of Eglin Federal Credit Union will get back to me and send me those videos as quickly as he can. It just has been the holidays, and I need him to give me a call back to make sure how quickly he can get them back to me.
What's your argument? Let's assume we don't have those videos, which is where we're at today. What's your argument regarding this? Because that's not the sole basis of their argument for a bond.
Your Honor, he has had a charge that he received while he was out on bond. Your Honor, I do not believe that he will abide by the conditions of any bond, and as well in the...
So you're disagreeing that this wasn't over some issue regarding the GPS monitor and whether it was charging at night or whatnot?
Your Honor, I do think we disagree about whether the unit was not charging correctly.
Yeah, but I'm just trying to figure out what is the issue. We can disagree about whether or not it was charging and whether it was a malfunction, but is that the issue? Because that's relevant. If that's what the issue is versus a new law charge, I want to understand the basis why a nonviolent defendant is being no bond.
Your Honor,
ask the question.
I do believe that he will not be able to abide by the GPS if he is let back out on bond, based on the history and Judge Polson revoking his bond for violations of the GPS. And additionally, in the 22 CF 1304 case, the victim in that case is a relative of Mr. Keel. And when I spoke to her about whether she wanted to appear at this bond hearing or if she had anything that she wanted the court to understand, she did want me to express to the court that this is a revolving door for Mr. Keel, that he gets let out and he continues to get new charges and leaves back in jail. And so she doesn't want to see him in and out of jail, but she's kind of at her wit's end about what to do and how to help Mr. Keel. So in that regard, again, the state doesn't believe that there are any conditions that Mr. Keel is going to have the ability to abide by, and would request that the bond remains.
Your Honor, let me briefly respond to that.
Sure.
With respect to that assertion by the states about the victim in the burglary case, just so the court has some additional context, that particular residence, Mr. Keel resided at that residence with his parents before his most recent incarceration. While he was incarcerated, his sister. His sister, the alleged victim in this case is his sister. Okay. And it's because she's asserting an ownership interest in that particular property. She doesn't reside there. She's an out-of-state resident. That particular residence is now in probate, and his sister is trying to assert an ownership interest and preclude him from accessing the house that he was residing in. So just so the court has some full understanding, this is a probate dispute that's unfortunately spilled over into a criminal matter. Because Mr. Keel also has an ownership interest in that residence that he was residing at, taking care of his parents before they passed. Again, he's asking for the reinstatement of his previously issued bonds so that he can fight this on the outside. With respect to the GPS monitor, his assertion is that it was a malfunction. He'd been in contact with Mr. Lorenzo to try to remedy it. They were not able to reach an accord, thus the warrant. But it's his intent to comply with any conditions set by the court as a condition of bond.
And I look, Your Honor, as I said, mentioned there's a new law violation, but I don't see where a new violation was alleged in at least the order from Bridgewell Services. As I said, my case occurred technically in June, which would have been before one of these cases, so it's a warrant. So my case, again, was not a basis for any revocation, really just because of the violation of the GPS issue.
Okay. Court's going to reinstate bond. I'm going to reinstate a $5,000 signature bond. That's, what is yours? Yours?
It's a cash recovery, Your Honor. We were asked the court to make it a signature bond, which is what
That's what I'm doing. And I'm going to reinstate the other bond, the ROR, $2,000 signature. The condition of bond is going to be GPS at $1 a day and no contact with any of the alleged victims. So that can be a little tricky. You're dealing with, with your sister. It's one-sided. Just stay away from her. Don't take any of her calls. You can operate. You've got a probate issue. You need to operate through the formal means. Your attorney can explain that you can file papers in your probate case and whatnot. I'm not getting into that. Your attorney can advise you, but you need to understand everyone's eyes are on this. So you got to figure out this GPS. I don't know what the situation is, but I will just say this. It's stupid to be in jail because you can't get the GPS thing fixed right. So I'm just all I'm saying. So we've got enough people in jail. You got some issues you're going to have to deal with them. You got 3 separate charges. We're not dealing with those today. Those are, you'll have to deal with those. But at least they'll let you out. But, follow the terms of the bond. If you mess up this time, they ain't going to let you out. Okay?
I have one question.
That's your turn, sir.
Judge, while Mr. Keel is here, I just want to confirm with the court when his next court date is, because there's an inmate.
That's good. Thank you for.
Yeah, that was Mr. Powell.
Next pre-trial? Well,
Yes, Judge, I think that would be February 13th.
February 13th. Well, the inmates will be February 15th.
Okay.
All inmates can be, he's going to be getting out, February 13th.
Thank you, sir.
This is Samuel Jones for Mr. Powell.
Mr. Powell.
Good morning, Judge.
Morning, Mr. Powell. Hold on a second, let me find your case. Yeah. We know what number?
Oh, yeah.
Sorry, didn't see you the door.
I believe it's number 8. Did you need the case number?
Number 8?
It's Mr. Samuel Jones? Yes, Your Honor.
It's on the docket that I
Right
have.
there, Mr. Powell.
Good morning, Judge. Todd Adams on the record on behalf of Samuel Jones, case number 22 CF 2128. Judge, we're before the court on a motion to reduce bond.
Proceed. The court reviewed the motion, but go ahead and make your own.
Judge, I do have a few witnesses here to testify.
We're not going to have witnesses on a miscellaneous docket. If you're going to do that, you need to set it in the afternoon where we've got time. It's not a morning. This is a no witnesses docket.
Very well, Judge. For purposes.
I mean, I'm not trying to tell you can't do it, but it's not going to happen today.
I understand. For purposes of today, Judge, Mr. Jones, his bond is currently set at $500,000. There are 2 third-degree felonies. Counts 1 and 2 are aggravated battery, third-degree felonies. Counts 3 and 4 were subsequently added by the state that are both second-degree felonies. Mr. Jones, Judge, he doesn't have a bad record. This is something that
We have some defenses too I anticipate presenting. He's employed. His family is here and present. His mother, his mother of his 2 children. He has 2 twin girls that he does take care of. They have they're not together, they have a very cordial relationship where they split time sharing. He works, he takes care of the kids during the nights while their mother works, and she takes care of them. Well, they basically have a 50-50 time sharing arrangement. I'm not here to dispute the facts of the case, but we are asking for a more reasonable bond. This is certainly tantamount to no bond. They don't have the means to make a $500,000 bond. I believe the alleged victim in count 1 does have a prior record, and we do have it's not innocent as far as some of the things that were going on in this case. I am asking the court to reduce it to something along the lines of, according to 3rd-degree felonies and 2nd-degree felonies. Like I said, he has strong family ties. We're asking for a GPS marker, whatever the court would deem appropriate to at least allow Mr. Jones an opportunity to afford a reasonable bond, whether it's GPS, certainly no contact with an alleged victim, but $500,000 is very, very steep on these particular charges. And so I believe they can make something around between $30,000 and $50,000. I think that's reasonable based on 2 second degrees and 2 third degrees. But other than that, Judge, without presenting testimony today, that would be the only argument I would have.
The state is asking the court to leave the bonds currently set. That's based on the allegations at issue in the case in the context of Mr. Jones' lack of compliance with orders of law enforcement and the court. In terms of criminal history...
I'm sorry, say that again?
Yes, sir. That's based... I know I'm speaking quickly, Your Honor. So that's based upon the allegations in the present case, but that's also in the context of Mr. Jones' history of a lack of compliance with orders of the court and of law enforcement. So... What do you mean? Yes, sir. So in 12 CF 263, the original allegation in that case was that Mr. Jones was found with crack cocaine and approximately $1,400 in the context of a traffic stop.
So is this an open case or is this a resolved case?
No, Your Honor, this is resolved. This was a conviction. So in that case, Mr. Jones was sentenced to probation. That probation was ultimately revoked and terminated with a jail sentence based on Mr. Jones' association with individuals engaged in criminal activity and visiting a place where drugs were used. In 15 CF 2075, that's another case of a conviction, Your Honor, Mr. Jones was arrested after running from a residence where a search warrant was being executed after being found with MDPV, which is a controlled substance. He was sentenced to jail in that matter. I'm also seeing 2 other convictions, 17 CF 2275, that was a PCS pled down to possession of paraphernalia. 19 CF 695, to possession of paraphernalias, that was also pled down from PCS. Mr. Jones, as I'm sure the court is aware, does have a minimum mandatory sentence based on count 4 if he were to be convicted of that. I am seeing that he scores 55 months DOC.
I'm sorry, Judge, I believe this prior record is several years old. I didn't hear the actual years of that.
It was a 12 and 15 were the 2 cases that I said with facts, Your Honor.
12 and 15?
Yes, Your Honor.
And Judge, since then, I mean, Mr. Jones he's got twin girls. They're 2 years old. He's employed. He's taking care of his kids. Family's here to support him. We're asking for a reasonable bond.
So, I appreciate assuming what your defense attorney says, that you've been trying to do right by your kids and otherwise. There's two issues here that you need to understand that the court looks at very seriously. One is the alleged crime, deal with possession or use of a firearm. And the second is whether there were shots fired in the allegations. Both of those are present here. And for that reason, even more than the prior record, the court's not going to grant a reduction in bond at this time. We need to resolve this case, figure out where we're going with it.
Thank you, Judge. We have depositions scheduled, and we're working towards a resolution.
Very good. Thank you.
Thank you.
I need to, apparently there are some, I'm the duty judge, and there are some warrants that are, apparently need my attention. So we'll go ahead and take our morning break. Time to do that anyway. It'll probably be a good 15 minutes, but we'll be back and we'll finish up in the morning.
All rise, please. Circuit Court's in a 15
court on a VOP agreement that's been reached with the state. It's been signed by all parties. Under the agreement, the misdemeanor VOP would be admitted. He was previously adjudicated guilty on a misdemeanor. There would be revoke and terminate supervision, $100 VOP fee, $150 PD fees. Outstanding monetary obligations would go to judgment or lien after 6 months. And may I approach this new score sheet?
You may. Thank you. State in agreement?
Yes, Your Honor, that is the state's agreement.
Okay, Mr. Anderson, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
So, you heard your attorney state the terms of your plea agreement. It's also contained in your written plea agreement that you've signed.
Yes.
Have you gone over it with it? Make sure you understand what this all means. Obviously, you're revoking and terminating supervision, but there are some additional fees and costs that will go to a judgment or lien after 6 months. You had all your questions answered regarding this?
Yes.
And you believe it's in your best interest?
I do.
Okay. Based upon your testimony here today and the plea and sentencing agreement, the court will previously adjudicated guilty and will revoke and terminate supervision with the fees and costs to judgment or lien after 6 months.
And what was the total?
The total, well, let's give it to you, the individual. It's $100 VOP fee, $150 PD fee, so it's $250 total.
Your Honor,
You have some prior?
there would be whatever the arrearages were. I don't know if probation has that, but you could talk about probation to how much you owe, but you'll have 6 months to get it paid off.
You may have to follow up with them. They may not have it right here.
Okay.
But you go talk with her and she'll tell you where to go to get that information.
Thank you.
Thank you, guys.
Okay. So we'll go ahead and
Thank you.
walk through before the jail has asked that we do the female inmates first. So
Mitzi Hatcher.
This is Ms. Hatcher before the court. We have a plea agreement to be filed in her case. Ms. Hatcher should be number 19 on the docket.
correct. Thank you.
This is Ms. Hatcher. We have a plea agreement to be filed in her case. It'll be to as charged in count 1 of the information. In count 2 of the information, it'll be lesser included offense of possession of methamphetamine. There is a failure to appear associated with this case. The state is going to take no action on that as well. Ms. Hatcher will be adjudicated guilty. She'll be sentenced to 30 days in the county jail concurrent between count 1 and 2 with credit for all time served. $270 court cost, $150 defendant fee. No probation to follow. The defendant would ask for 24 months to pay those outstanding fines and court costs. Mayor Bergeron?
You may. Is that the agreement of the state?
That is the agreement with the state, Your Honor.
Okay, thank you. Ms. Hatcher, would you please raise your right hand, ma'am? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
Okay. I think you may have misstated. The plea on count 2 is to the lesser included of possession of paraphernalia. Yes. I believe you said possession of methamphetamine.
I apologize, Your Honor.
That's all right. I just want to make sure that
Yes,
we
sir.
get it right.
Yes, sir. It's two.
Usually it's me that's getting it wrong, so it's all right.
Yes, Your Honor. It's 2 paraphernalia charges.
Okay, very good. And which are both misdemeanor charges, which are important on your behalf. So, both counts, there'll be 2 possession of paraphernalia charges. You'll receive 30 days sentence in the county jail. You get credit for time served. They'll be run concurrently, so it's a total of 30 days. Plus the fees and costs. You're not going to be on probation, and the state will take no action on the failure to appear associated with the case number. We'll have 24 months to pay. You understand all this?
Yes.
Have you gone over all the legal ramifications? The main thing is this a final adjudication, waiving the right to go to a trial, to contest all this, making sure this is done and finished. Is that what you want to do here today?
Yes.
And you believe it's in your best interest to do so?
Yes.
Based upon that testimony, the court will accept your plea and adjudication of guilt on both the charges of possession of paraphernalia, 30 days, county jail, concurrent, credit for time served, and fees and costs that are contained. And the state will take no action on the failure to appear. Good luck, man. Next is Chloe Smith, I think. We're going to do the females first.
Chloe Smith.
Yeah, this is Miss Chloe Smith before the court. We have a plea agreement to be filed in her case.
I'm still doing that, right? You can announce the now, record of it.
The state will be filing a score sheet in this case, Your Honor. Ms. Smith will be admitting a violation before the court in 18 CF 690 and pleading no contest as charged of 22 CF 1885. She'll be adjudicated guilty in all counts and cases. In 18 CF 690, we're going to modify and reinstate supervision. We're going to add a condition of complete the road to recovery program and any aftercare, complete the original requirements, no contact with the co-defendant or any witnesses in that case, $100 cost of prosecution, $150 defendant fee. And 22 CF 1885 should be placed on 3 years of probation concurrent, and waive the cost of supervision, complete the road to recovery program and any aftercare, $615 court costs, $100 defendant fee. The plea agreement calls for Ms. Smith to be held until tomorrow. At what point she'll be released to her grandmother, Ms. Laura, tomorrow. Mr. Morrow will be taking Ms. Smith down to probation and parole to check in, and then over to road to recovery where she'll be placed in the inpatient program. May I approach, Your Honor? That's the state.
It is the state's agreement, Your Honor, and her score sheet will reflect a total of 36.2 months with a maximum exposure of 15 years. Now, we'll file that today.
So is this a downward departure?
No, I'm sorry, it's 36.2 points, I'm sorry, I misspoke. So it's not a downward departure.
Okay, thank you. So Ms. Smith, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So, you heard your attorney state the terms of the plea agreement?
Yes.
Yep. Did you have a question? No.
Yes, sir.
Okay. You just have to raise your hand just when you get sworn in, and then you don't have to. I swore you in, didn't I? Did I swear you in? Yeah. So, obviously the key to this whole plea agreement is your condition to participate and complete the road to recovery program along with aftercare. And so, in reality, you know, this isn't the end. You know, it's kind of an ending of sorts, but it's not. Really, it's the beginning. And it's an important beginning for you. And are you willing to participate in this program? Because they're not easy. Just because you participate in them, and it's just tough dealing with this. And I hope you've come to that conclusion, because it takes a certain amount of I want to get this done. And it's been my experience seeing it from a lot of folks. But you're willing to do this?
Yes, sir.
And you believe it's in your best interest to have this final adjudication of your case? You know, you're waiving the right to go to a trial and to contest all this. You believe this plea agreement is in your best interest?
Yes.
You had a chance to go over it in detail. I see you signed the plea and sentencing agreement as well. You've gone over it in detail with your attorney. Make sure you understand all the ins and outs from a legal standpoint, what it means to you, as far as your record, etc.
Yes, sir.
Okay. You don't have any other questions regarding this? You believe it's in your best interest to enter into this plea agreement?
No.
Okay. Very good. Based upon that testimony, the court will accept your plea agreement. There'll be an adjudication of guilt on all counts in all cases. On 18 CF 690, we'll modify and reinstate probation with the added condition to participate and complete the road recovery and aftercare and any other original requirements. No contact with the co-defendants or witnesses. That's important. Stay away. Obviously, for a while, you're going to be a road to recovery. When you get out, that's an important thing. You got to create new situations. You don't fall into old patterns. 22, they'll talk to you about that a lot of road recovery. So 22 CF 1885, 36 months probation, concurrent, waive cost of supervision, again, same thing, road to recovery with costs and fees. Specifically, as stated by your attorney, you'll be held at the county jail until tomorrow. Then you'll be released into the custody of Miss Laura DeMara, who will transport you to parole and probation located in Kelly Avenue, and so that they can process you and transport you to the Rotary. Okay, any questions?
If I may approach, I did complete the score sheet.
I'm sorry?
If I may approach, I did complete the score sheet. I showed it to Mr. Gates as well.
No objections, Your Honor. And I talked with the state this morning. There was some property that was taken as part of the arrest in 22 CF 1885. They have no objection to returning the property. I'll try to get the files in the next week or so for Ms. Smith to be able to that property.
Appreciate you putting that on the record.
Right this way, this way. Burnett should be. Caitlin Burnett. I gotta get your fingerprints.
Caitlin Burnett.
That's correct, Your Honor. Miss Caitlin Marie Burnett is before the court in 22 CF 2281. All parties have signed a plea and sentence agreement for a change of plea. There will be a withhold of adjudication under the agreement, Your Honor. It's as charged to a third-degree felony grand theft auto, and then count 2 was a possession of misdemeanor level of cannabis, first-degree misdemeanor. Under this agreement, there will be withhold of adjudication, as I stated, 6 months drug offender probation with a 7 p.m. to 7 a.m. curfew, followed by 2 years of standard probation on count 1. There will be 11 months, 29 days concurrent probation on the misdemeanor count 2. Reserve jurisdiction on restitution for 180 days. $615 court costs, $150 public defender fees. Substance abuse evaluation within 30 days. With any recommended treatment to commence within 60 days. 50 hours community service. No contact with the victim, Johnny Moore, or with co-defendants, and their names are in here. I'll state them: Sebastian Orr, O-R-R, and Jamal, J-A-M-A-L Thompson. No trespassing at Johnny Moore's house, residence 298A Union Street, Fort Walton Beach, Florida. Maintain gainful employment or complete 2 applications for jobs per week. Anti-theft course. May I approach with the agreement and score sheet, Your Honor?
You may. Is the state in agreement?
Yes, Your Honor, that was the state's agreement.
Okay, Ms. Burnett, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
I do, Your Honor.
So, your attorney laid out in detail the terms of the plea and sentencing agreement. Now, it's kind of in depth. There's a lot of stuff to it, but it's also contained in your plea and sentencing written agreement that I see you signed. I just want to make sure you understand what you're doing and that you're entering it freely and voluntarily. So my first question is, have you gone over this plea and sentencing agreement in detail with your attorney to make sure you understand what's in it?
Yes, Your Honor, I have.
And you believe it's in your best interest to enter into this plea agreement?
Yes, Your Honor.
You understand that by entering into this plea agreement, you're waiving some valuable legal rights, right? To go to a trial to contest this. This will be a final resolution of your case. Do you understand that?
Yes, Your Honor.
And you believe it's in your best interest to do so?
Yes, Your Honor.
Any further questions on this?
No, Your Honor.
Mr. Medina.
Sorry to interrupt, Your Honor.
That's all right.
Probation was kind enough to remind me of the 7 p.m. to 7 a.m. curfew. We would ask that it be subject to approved work exceptions. So if she has to go to work after 7, she can get approval through city probation.
Absolutely. Do you want to make sure and put that in there?
I'd be happy to, Your Honor. May I approach?
Sure.
Thank you.
That's important.
I'll just put an asterisk, subject to work exceptions after the word curfew.
Perfect.
And she's initialing subject to work exceptions, Your Honor.
Okay. Mr. Medina, are you in agreement on as to the score sheet?
Yes, Your Honor, and I have showed that to Ms. Burnett.
Thank you.
Yeah.
You may. Very good. With that very minor little change, the court will accept the plea and sentencing agreement as stated previously, and there'll be a withhold of adjudication on both counts. There'll be 6 months drug offender probation with the 7 to 7 curfew, followed by 2 years of standard probation on count 1, 11 months, 29 days, concurrent probation as to count 2, reserved jurisdiction on restitution for 180 days, additional fees and costs, must obtain your substance abuse evaluation within 30 days, so you need to jump on that right away, okay?
Yes, Your Honor.
And follow up with any recommended treatment to commence within 60 days. You've got community service hours, and then you've got no contact and no trespassing. You're clear about that?
Yes, Your
And
Honor.
understand about that no contact.
Yes, Your
It's
Honor.
important. It's one-sided. So if they approach you, you're in violation. They're not. You need to stay away from them, okay?
Yes,
You need
Your
to
Honor.
walk away from them. If they call you, hang up, okay?
Yes,
Just
Your
stay
Honor.
away. It's not going to be a problem, but it's your obligation to stay away from them. Do you understand that?
Yes, Your Honor, I do.
Okay, any questions?
Do I have 24 hours to check in?
She'll need to check in upon release.
I'm sorry?
She'll need to check in upon release.
Okay. As soon as you get, if you can go over there today, that'd be good.
Okay. What about
We're
what
not
time?
doing by 4 p.m.
So what if I do release after 4 p.m. by tomorrow morning?
8 o'clock tomorrow morning.
Thank you.
It's at 13 Kelly Avenue, Fort Walton Beach, as we discussed.
Yes, sir.
Thank you.
Okay. Very good. Thank you.
Jessica Carroll.
Jessica Carroll?
You never handed it to me.
Oh, that's right. Your Honor, yes, ma'am. Your Honor, Miss Jessica Carroll is before the court in 22 CF 1068. We have a violation of probation plea agreement that's been signed by all parties. Well, actually, Miss Carroll is signing it. I went over it with her. And the state will be submitting a score sheet. It's for a DOP, Your Honor. Felony DOP would be resolved. She was previously adjudicated guilty. There will be a revoke and terminate supervision, 8 months, Okaloosa County Jail with credit for all time served, $100 VOP fee, $150 public defender fees. Outstanding monetary obligations will go to judgment 12 months after release. May I approach, Your Honor?
You may. Is that the agreement? State.
Yes, it is the agreement of the state, Your Honor.
Ms. Carroll, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of the plea agreement. Is that your understanding of what the plea agreement is?
Yes, sir.
I see you've signed the written plea agreement. It contains the same conditions.
Yes, sir.
Have you gone over this with your attorney? Make sure you understand all the legal ins and outs of this plea agreement.
Yes, sir.
And you believe it's in your best interest to enter into this.
Yes, sir.
You realize that by entering this plea agreement, you're waiving the right to go to a trial, and this will be a final adjudication of your case. Do you understand that?
Yes, sir.
Okay. And you've had all your questions answered.
Yes, sir.
You believe it's in your best interest to enter into this plea agreement.
Yes, sir.
Based upon that testimony, the court will accept your plea agreement. You were previously adjudicated guilty. will revoke and terminate supervision and sentence you to 8 months in the county jail. You will get credit for all time served, along with some fees and costs contained in the plea agreement, and you'll have 12 months to pay it after release, and then it'll go to judgment. Okay,
Yes, sir.
questions?
No, sir.
Thank you very much.
30 days.
Marjolee Cordial.
Marjolee Cordial.
Your Honor, Marjolee Cordial is before the court in 21 CF 1622 and 22 CF 2975. The 22 CF 2975 is a new law case, and she is going to be resolving both cases with a plea and sentence agreement that encompasses the prior misdemeanor VOP in 21 CF 1622. I've been over this with her, Your Honor. She is signing her plea and sentence agreement, and the state will need to sign it as well. And I apologize for not getting that done. Thank you. We have a score sheet, Your Honor. I'm just showing her the score sheet to make sure everything's.
And just as a reminder, she's also on the 130 dockets.
Okay.
Of her arraignments.
Thank you. May I approach you?
You may. It's all right. How do you pronounce your last name, ma'am? Cordial?
Cordial, like Cordial Taco Cover Charity.
Okay, Ms. Cordial, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement.
Yes, sir.
You can put your hand down. And I see that you've signed a plea and sentencing agreement that contains those same pleas and those same terms and conditions. Have you gone over this with your attorney and had all your questions answered regarding this plea agreement?
Yes, sir.
You believe it's in your best interest to enter into this plea agreement?
Yes, sir.
You understand that by entering into this plea agreement, this will be a final adjudication of not only the violation of probation, but the new law charge that was filed. Total resolution of your cases going forward. Do you understand that?
Yes, sir.
You believe it's in your best interest to do so?
Yes, sir.
And you have any other questions of your attorney? You satisfied with your legal representation?
Yes, sir.
Okay. Very good. Based upon that, the court will enter an admission of the violation and an adjudication of guilt on all charges, revoke and terminate supervision, and there'll be 6 months sentence in the county jail, concurrent for each of the charges. You'll get credit for all time served, and additionally, the fees and costs contained in the plea agreement will go to collections, so you have 12 months after your release to pay those. Then it'll go to collection.
Yes, sir.
Okay. Question?
Yes, Your Honor. I may not have fully announced this, but the state would be agreeing that she can do eligible costs for at least some of her court costs, and she could work with the clerk's office on that.
I'm sorry, I'm not following.
My understanding is the clerk's office will accept community service for a portion of the $615 in new court costs, and I'm not sure how much of it would be eligible, but the clerk of court...
Is that something that we need to put in our plea and sentencing agreement? Because I've never heard that, put in a plea and sentencing agreement. Is that something we need to do, or you just letting her know? I don't mind that.
I did
It's
have-
new to me, and I'm trying to understand.
Yes, Judge, we've done that many times, and we do expressly point it out that the parties are agreeing that she may do community service for eligible costs, but Madam Clerk may want to clarify, but my understanding is that not all of it can be worked off through community service. The clerk's office is helpful to people that want to do community service where it's approved by the court because of her financial situation. She was asking for that within the court's and the clerk's discretion.
As long as it's announced on the record and then said that you don't object to it, will accept community service for all eligible costs, eligible fees, things like that are not eligible for the other costs.
Okay. Well, court absolutely does not object to the defendant if she can work off some of those through community service hours. And again, if it needs to be included, you just let me know. And
Yes, Your Honor, and it's not mandated. She has transportation problems. It may not be possible for her, but she did ask for that alternative if it became feasible.
Sure. Okay. Very good. Anything else?
Thank you.
Okay.
Thank you. Cox?
Nina Cox.
Your Honor, Nina, how do you pronounce your middle name? So, Cox in 19 CF 1465 is before the court. She also, Your Honor, has a case on the afternoon docket. It's a new law case, 22 CF 3023. And so that the jail doesn't have to hold her here to the afternoon. What she would like to do is at this time deny the BOP in 19 CF 1465. And if we can go ahead and have her enter a plea of not guilty in 22 CF 3023, they can take her off the afternoon docket.
Very good. When do we want to come back?
Your Honor, I would like to keep her on February pretrial. I think that's the next pretrial.
You want to go to a pretrial or go to another miscellaneous day on the bottom? Well,
I think we
have
can
a
just
new
go
law
to February 15, Your Honor.
Okay. So we'll come back, continue the next pretrial on February 15th.
Okay, thank you.
And that's on both cases.
Yes, Your Honor.
Miss Evans-Love?
Your Honor, Ursula, how do you pronounce your middle name now? Simone Evans-Love is before the court, and she is signing a plea and sentence agreement that actually is a resolution of VOPs, not new law cases, Your Honor. Is this what you want to do?
Yeah.
I've been over it with her, Your Honor, and I'm going to put it on the record with a little bit of an explanation in just one moment, Your Honor.
The last person, did we do her 130?
Yes, we did.
Right. Ms. Cordial, that I just reported. Excuse me, this is back to you. The 130.
Pardon? No, it's not new. I had it in the, there are no new cases. It's Your Honor, she has a misdemeanor case that's not before circuit court. It's in county court, and I've indicated that cannot be addressed. I don't think that the state will agree to address that today. I do not represent her in a misdemeanor case that she has pending. Your Honor, she has 21 CF 145, 21 CF 203, 21 CF 713, and 21 CF 771 that are all felony BOP cases. And under this agreement, she would be admitting the violation. And she was previously adjudicated guilty in these cases. There will be revoke and terminate probation, 24 months concurrent DOC between all cases and counts with credit for all time served, $100 BOP fee times 4 for the 4 cases, a total of $450 public defender fees. Monetary obligations would go to collections 24 months after release. All parties have signed the agreement. I want to make sure I explain to her, Your Honor, the state, it's because it's a BOP, it's technically not required to have a downward departure, but that's the essence of what the state is agreeing to, because her guideline sentence computation would be 29.550. The state doesn't have to, it's not done as a mitigation factor, Your Honor, but the state is agreeing to allow her to do only 24 months.
Very good. Stay in agreement.
Yes, Your Honor, that was the state's agreement.
And Your Honor, she may want to address the court on the misdemeanor, but I told her that I could not handle that. I will tell her that I will let her misdemeanor lawyer know right away, and he may be able to do a plea in absentia or somehow accelerate that case. But I don't think we can resolve that today.
There's no way we can run the reason why I violated was because of the misdemeanor charge. It's a new law violation which violated my probation. I understand why it could be ran concurrent with this VOP today.
It may be, but you'll have to do that in county court, is my understanding. But there were also, for the court's awareness, there were also technical grounds that basically I don't think that she completed Phoenix House as required. Keaton.
The state in agreement, there's no way to resolve the misdemeanor case.
What was the charge?
It was just a false name to a Leo.
When she got picked up, allegedly there was a false name.
Your Honor, if the court is open to it, I would ask the court to give her credit for time served on that misdemeanor case. We can add it into the...
Yes, do we have a case number, and we just need to make sure there's an information? Since the state's willing, Your Honor, then she won't have to come back.
Okay.
Thank you so much.
Thank you, ma'am.
Do you want to write that in here, Mr. Medina?
Yes, Your Honor.
Thank you.
The information has been filed, and the case number is 22
Hold on, 22 CF.
NN
Oh, I'm sorry.
4326.
4326, and so I am writing that in, Your Honor, if I may have a moment of indulgence. And that was false ID to a Leo?
False name to a Leo.
False name.
So all my cases are closed now, right? Since that misdemeanor is being ran concurrent with this.
Unless you have something else.
No,
Now, in the misdemeanor, the state's offer, which is going to be included, is credit for time served. So it's basically being resolved.
Good.
No further probation, no further time as a result of that.
Yes, sir, that's what I'm
They're
yes, sir.
accommodating you on this.
Thank you so much.
So, Your Honor, I'm going to have her initial that A/G for adjudication of guilt in 22 MM 4326, TS for time served, and there would, I think, also be 270 court costs and another $50 in PD fees, something like that. So I'm writing 270 court costs, 50 PD fee. We don't need the score sheet on the misdemeanor.
No, I mean...
Oh, did I? Yes, ma'am, I'm providing that. Yes, ma'am.
You got it?
Okay, so my misdemeanor is done.
Once the judge pronounces sentence.
Ms. Evans-Love, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement, which will include your misdemeanor charge that's in the misdemeanor court. You can put your hand up. And obviously the core of this plea agreement is that on all the charges, there'll be revoke and terminate probation, and you'll receive 24 months DOC. They'll all be concurrent. That's except for the misdemeanor, just credit for time served, because that's done.
So my
as of
misdemeanor is
today.
over with.
Right.
Yes, ma'am. done. And you do have a number of fees and costs that will go to collections 24 months after the time of release. So, I see that you have also signed the plea and sentencing agreement that contains this. Have you gone over this in detail with your attorney?
Yes, sir.
Make sure you understand all the legal ins and outs of this. You had all your legal questions answered.
Yes, sir.
Obviously, the most important thing is you understand that this will be a final adjudication of all of these cases.
Yes, sir.
So you're seeking and you're waiving the right to go to a trial to contest these. This is done.
Yes, sir.
Finish it. You will get credit for time served on your sentence as it relates to that.
Will I get my time that I did do in Keaton too? Can I get that time too?
No, Your Honor, my understanding is that the Keaton facility is part of her probation, and that does not count as time served. Does probation have any information on that?
That's my understanding as well.
Now, ultimately, the jail would do a time served calculation, so I don't have a definitive ruling on that.
Nor do I.
I don't think the jail will accept that, so I don't want her thinking that the jail will.
Right, I agree. So is that your understanding, ma'am?
Yes, sir. Yes, sir.
Okay, I mean, we're not telling you exactly how much credit for, we're just saying you will get credit for time served as allowed. The jail makes that calculation, so you're willing to go along with this agreement?
Yes, sir.
Not knowing the exact amount of time, right? You understand that?
Yes, sir.
Okay. Do you have any further questions regarding anything relating to your plea and sentencing agreement?
He said something about.
Ask him first. Ask your attorney first, and then I want you to say something that might mess up here.
So, Your Honor, I was explaining to Ms. Evans-Love that because she did not pick up a new felony, technically speaking, there did not have to be a downward departure. However, the state is in essence, had there been a need for a downward departure, the state is in essence giving her one. But it doesn't have to be reflected on the score sheet because there was no new felony.
Okay. Any questions about that, ma'am?
No, sir.
So you're clear about what we're doing here today?
Yes, sir.
You believe you've gotten good legal representation here?
Yes, sir.
You've gotten all your legal questions answered?
Yes, sir.
Very good. Based upon that, the court will accept your plea agreement. We'll sentence you according to the plea and sentencing agreement. Previously adjudicated guilty, revoke and terminate probation, 24 months DOC on all counts, concurrent fees and costs. The 24 months DOC is everything except the misdemeanor. Misdemeanor is separate, get credit for time served, that's done.
Yes, sir.
Okay?
Thank you.
Very good. Thank you very much.
Yes, sir.
Thank you. So that's all we've got as far as the females. Okay, I think we've got a couple of inmates that are without attorneys.
Cedric Beacham was one of them, unrepresented.
Yeah. Would the state announce Cedric Beacham, it's number 12?
Yes, Your Honor, this is 20 CF 856 and 20 CF 1938. These are violations of probation, which have to do with a new law charge, and 22 CF 2923, Your Honor.
Okay. Is that on this afternoon? Has that already been?
I think that has already been arranged, Your Honor.
Okay.
Yes, Your Honor.
So, Mr. Beacham, these two violations of probation based on the new law charge, you do have a right to have an attorney with those violations. You want to have an attorney appointed?
Yes, sir.
Okay, the court will appoint public defender in both of these cases. And what I'm going to do is I'm going to enter on the violations of probation. I'm going to enter a denial on both of those. That's just like a not guilty. Okay, so hold on. So that you don't give up any rights, you'll have a chance to meet with your attorney. Mr. Medina, question?
I may be incorrect, but I think that Mr. Beacham appeared with a private lawyer at his last court date. Is that private lawyer not taking your DOP cases?
I'm not sure they're still working it out because we just got some of those cases while I was locked up, so.
So, Your Honor, I would ask that he complete the public defender application form so it could go to clerk to make it official. Sure. In the meantime, he can be working with his private lawyer to see if she's going to take the VOP cases too. So it'd be a provisional appointment for purposes of today. I'll give him my card.
I would agree.
All right, so
You
what
have
is
to
this,
fill out.
what is this paper?
That is the application for the public defender.
Okay,
You fill that out completely and then submit it through the jail and it will go to the clerk. And if you're eligible, they'll appoint you.
okay, thank you.
Official. Thank you.
Yes, sir.
Thank you.
Any other questions? That's all we're doing for today. We're just entering a denial. You're not giving up any of your rights. We're just trying to, bring all our cases together at once. What is his other case? When is it? Is it up for pre-trial?
It's on the February 15th docket, Your Honor, and just so the court's aware, I do know that when he was at the arraignment on the new case, he said he was speaking with Ms. Dudley. Ms. Dudley has not entered a notice of appearance on the new case or the violation. So if you would fill out that application for the public defender to make
Okay. Well, we'll continue both of these violations of probation also to run with your other case. So that'll also be on February 15th at 9 a.m.
But he's not on the afternoon docket today.
No.
Thank you.
No.
Thank you.
Okay.
So I'll
Richard Giles.
see you if you're getting the public defender. Just submit that application today.
Okay, so,
Fill it out completely.
yes, I will. All right.
Just come up to the podium, sir.
Your Honor, this is Richard Keith Giles. We have two cases in the docket today, 22 CF 2995, 22 CF 1221, 22 CF 2995. This is an alleged.
Whoa. I only have one case for you.
Yes, Your Honor, and I'll try to help out here. He's got the VOP on the morning docket, which the state announced. On the PM docket, he has 22 CF, she has 22 CF 2995, Your Honor. This is Miss Ricky Giles. And I've been appointed on the case in the afternoon docket, but I have not been appointed to her VOP.
So you do have a right to have an attorney appointed on the violation of probation, which is the one that's on the calendar for this morning, which is 22 CF 1221. I assume that's based on the new law violation.
Yes, Your Honor.
You do have a right to have an attorney in that one. You want me to appoint you the attorney?
Yeah, sure.
Court's going to appoint you the public defender so you can do. I'm going to enter a denial. That'll just kind of preserve your rights, so you can meet with your attorney. And then this afternoon, we'll go ahead. You want to enter a plea, not guilty in those as well?
Yes, sure.
Okay, so we'll enter not guilty pleas for this afternoon, so you don't have to come back this afternoon. We'll give you a chance to meet with your attorney and kind of figure out where you're going, okay?
Yes, sure. We can have both been set for February 15th.
Okay. February 15th at 9 a.m. Okay.
Fitzwater also on the PM.
Right.
Yes, Your Honor. Travis case on behalf of Mr. Fitzwater. He has a case on the morning docket, which is 22 CF 295. And then the afternoon docket, he's got 22 CF 2963. The state and I had discussed two offers, which I've gone over with Mr. Fitzwater. He's also being presently screened for the vet court program. He's asked to continue with this grant for vet corps program as they do provide a bit more services that he might be able to take advantage of. So if we can enter a denial on 22 CF 2.5 and a not guilty plea on 22 CF 2.963 and have them both set for February 15th.
Okay. Court will do as you requested, enter those two pleas, and we'll come back on February 15th, and you can, hopefully at that time you'll be able to, review your availability of the vet court, and if that's available, then certainly that's a good program. Okay. Very good. Thank you very much. Okay.
Tony Tatum.
Yes, Your Honor, this is Mr. Tatum before the court. So if you give me a second to make my note from the last case. Mr. Tatum is before the court on a violation of probation in 2 cases. The allegations based upon a new law violation and set of rescue. If we can enter a denial in Mr. Tatum's cases this morning and have them set for I think the February 14th is the next BOP date without subpoenas.
Well, it's actually, we've got a miscellaneous on January 17th. That may be a little too quick.
Yes, Your Honor.
So we'll come back on February 14th at 9 a.m.
And if I can get a
we'll enter a denial.
If I can get a resolution before then, I will definitely move Mr. Tatum up to get the case resolved as well.
Okay, now you can do that anytime. Okay, thank you very much. Robert Taylor.
I think this is my last one on the morning docket, Your Honor, Mr. Robert Taylor. At this time, if we can enter a denial on the violation of probation and ask the court to continue without subpoenas.
And you want to come back on February 14th?
Yes, Your Honor.
Okay, so we'll come back February 14th at 9 a.m.
Thank you, Your Honor.
Thank you. Okay. Mr. Medina, Courtney Heirs.
Yes, Your Honor. I'm not leaving the courtroom, I'm just walking back.
No, that's all right. No, I just want to let you know we're up with your group.
Thank you, Your Honor. Courtney D. Heirs is before the court in 19 CF 1957, Your Honor. All parties have signed a violation of probation agreement under which he will be admitting the violation. He was previously adjudicated guilty. Under the agreement, there would be a revoke and terminate of supervision. There would be 11 months, 29 days. It's written as 11.29 months OCJ, Okaloosa County Jail with credit for all time served. $100 VOP fee, $150 public defender fees, outstanding monetary obligations to judgment, 24 months after release. And do you want to submit a score sheet?
Yes.
The state will be submitting a score sheet, Your Honor.
And Your Honor, I can represent to the court that this will not be a downward departure.
Very good. So, Mr. Harris, would you please raise your right hand, sir? You swear or affirm the information you're about to provide in the court is the truth, nothing but the truth, so help you God.
Yes, sir.
So I see that you have signed the violation of probation plea agreement that contains the same, put your hand down, that contains the same terms as just stated by your attorney. Is that your understanding of what the plea agreement is?
Yes, sir.
1129? And you understand that by entering into this plea agreement here today, you're waiving some valuable rights. Right to go to a trial, right to contest all this. Have you gone over this with your attorney?
Yes, sir.
Make sure you understand what the legal ramifications are of this plea agreement?
Yes, sir.
You believe it's in your best interest to enter into this?
Yes, sir.
You believe you've gotten good representation?
Yes, sir.
You got all your legal questions answered?
Yes, sir.
Nobody threatened to coerce you to get you to enter into this plea?
No, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea. There'll be an admission of the violation, an adjudication, previously adjudicated guilty. We'll revoke and terminate supervision. That'll be done. Sentenced to 11 months, 29 days in Okaloosa County Jail. You get credit for all time served, and you'll have the fees and costs that are contained in the plea agreement. Those are payable within 24 months after the release, or it'll go to a judge. Question? Thank you. Richard Valledino.
Yes, sir. Your Honor, Richard Salvatore Valledino Jr. is before the court in 22 CF 2996. He also, my understanding is, might be on the afternoon docket. He has a total of 4 cases, Your Honor. One of them is represented by Marty Notes, Esquire. We have been in an extensive communication with the state. We think we have the framework for a plea and sentence agreement. Unfortunately, one of the 4 cases that he has is 23 CF1. That apparently was the first case of the new year. Where the state is waiting on the filing information at the clerk's website and so forth. So it does not have an information filed yet, so we cannot resolve it today. But I'm anticipating that he will be getting an agreement, and that Marty Notes, his lawyer in, I think Mr. Notes is the lawyer in the 2364 case, 22 CF 2364. I think that basically, as soon as we hear back from Keaton or get an information, he has a recommendation for Barstebet Keaton. That's a state probation DOC facility, so I think we can do a deal as soon as we get the information filed in 23 CF1. That will be Barstebet.
I don't want to rush things, but we've got a court date next week.
That would be great. I hope that we'll
January 17th, get him on moving so you can get to your Keaton.
That'll be.
I'm fine with that, Judge, if we want to.
Okay, so let's try that. And why don't let's make sure we have all the case numbers.
Yes, Judge. The case numbers, just for the record, and they're all in the draft agreement that everybody's more or less tentatively approved, except for the court, of course. 23 CF1, 22 CF 2064, which was a felony and misdemeanor DOP case that the public defender is handling, as well as 23 CF1, which the public defender would be handling. 22 CF 2996. Which the public defender would be handling.
And that's on this afternoon's docket, and you're entering a not guilty plea.
Yes, Your Honor. We would do a not guilty plea for that.
Okay, so we don't have to bring him back this afternoon.
Yes, Your Honor. Then a denial for purposes of today, and 22 CF 2364, which, excuse me, that's a not guilty represented by Mr. Notes, but I guess it would be up to Mr. Notes what to do in that case. I do believe that conflict was cleared up, but because of how it...
Whatever it is, we want that case to track on the 17th. So that if it's something that has to be notified by Mr. Nope, somebody's got to make sure he knows it, so we can get all that resolved.
He may have been hoping that everything would get resolved today. I think that he would want the court to just, if the court would, to enter a not guilty in the 22 CF 2364, so we didn't have to stay on the docket till the afternoon. I'm sure.
Okay, well, so he's got another one on there this afternoon?
You know, he may have already had a plea day on that one with Mr. Nose. I think he already pled not guilty.
Okay.
I'm sorry, Judge, for it's just confusing.
Okay, got it.
Yeah.
Okay, so we'll come back on the 17th, hopefully.
So Mr. Nose,
universal will be resolved, through a plea agreement, and then you can move on from there.
Thank you.
Okay, good luck.
Thank you, Your Honor.
Okay. Christopher Brown.
Your Honor, this is a extradition issue with Mr. Brown. The public defender's office was assigned to represent Mr. Brown. It appeared that the time frame for keeping him incarcerated has expired, so we filed a motion for discharge of Mr. Brown. And I don't know if the state has any position on that motion. I think it's clear as a matter of law that he shouldn't be in jail right now because the paperwork that that would allow, I believe it's Oklahoma, to come and get him, hasn't been filed. He has not been extradited, and he has not agreed to be extradited.
Your Honor, Mr. Medina warned me that motion was going to be filed, but I honestly have not seen it. I did not know it had actually been filed until you just said that, so.
So here's what we're going to do. We're going to, Mr. Medina believes that the time has expired. What I'm going to do, you can either do one of two things. One, either you can look at it now, or we can come back, bring him back this afternoon, deal, because he shouldn't be in jail. He shouldn't be in jail. So we're not going to wait.
Certainly, if he doesn't belong in jail, I'm not asking for him to stay.
I know.
But if we can bring him back this afternoon and.
Yeah, we're not going to, I don't want to wait, next week or
Correct,
a month from now.
I wouldn't ask for that, Judge. If
Okay.
I can just have until the afternoon to look at this
Okay.
and then. if we can bring him up.
Yes, sir.
Okay, can we bring him back this afternoon?
Yes, sir. Thank you, Your Honor. And I'm going to give Ms. Sharpless my copy, Your Honor.
Okay.
I think I know what
We'll try and get it resolved here this afternoon, Mr. Brown.
Let you back, let them know that you're standing over that over. Yep, Jonathan Bryant.
Jonathan Bryant.
Your Honor, Jonathan R. Bryant is before the court in 14 CF 2050 on a status. This is a case with Assistant State Attorney Basso.
Right.
Assistant State Attorney Basso and I have had extensive discussion, including in the last 24 hours. And what the state has agreed to do is file an answer on the 3 grounds that were granted the right to an evidentiary hearing by Your Honor's predecessor, Judge Polson. And basically then I would be getting with him with the answer, and we think the state will be filing its answer within the next day or two. So if we could put him on the docket for a week from today, if the court would permit, we can continue our status to a week from today. And I'll be getting with him hopefully by the end of the week with the state's answer, and he'll be able to, in a more informed way, appear before the court on the status conference to make a decision on whether to schedule this for the evidentiary hearing to which he is entitled.
Very good.
That's accurate, Your Honor. We'll have that to Mr. Medina. I would expect within the next day or two.
Okay, very good. Yeah, I know it's been outstanding for a while, so my notes said that we were going to try and schedule something, but we'll wait another week and figure out where we're going.
Yes, Your Honor. I think the state...
We'll set it for a hearing.
And I do appreciate the state has agreed to do that, so that'll help you meet with him. Thank you.
Sure, okay. Castillo.
Jermaine Lee. Jermaine Lee.
Who is this?
Jermaine Lee.
Your Honor, this is Jermaine D. Lee, L-E-E, last name before the court in 20...
Where's Alessi Castillo?
I must have skipped and forgot it.
That's all right. That's all right. We want to make sure that we're
Yes, sir.
trying to keep my paperwork straight. Okay, Jermaine Lee.
Yes, Your Honor.
Got it.
Your Honor, Mr. Lee, I do want to clarify that this is signed by Mr. Lee. When he signed it, he was hoping to get 11 months, 29 days Okaloosa County Jail. The state, I've informed him, wasn't willing to do that. It's at 12.1 months, so, but it would be DOC instead of 11 months, 29 days jail. So I'm having him initial on the 12.1 months DOC if that's what he wants to do. It is the state's best offer. And my understanding is, I've been over it with him, that he intends to take that offer. Just initial by the 12.1 months, so you understand the change. And Your Honor, the state is signing this, and then I'll announce it. Gee, you gotta get behind that. Yeah, no worries. That's all right. No worries.
Your Honor, I apologize if I don't have this score sheet. The printer failed me this morning, but this is going to be a downward departure of a couple of months. He scores, I think, 15 months as the lowest permissible sentence.
And what is the basis for the downward departure?
Legitimate and coerced probation.
Your Honor, I'm not sure there was a new law felony, so I'm not sure technically speaking that it had to be done as a downward departure, but the state's stipulating that it is if it's applicable.
That's right.
Your Honor, under this agreement, he was previously adjudicated guilty on a second-degree felony. He represents to me that he did some fairly significant jail only on this case, a number of months. I told him I don't keep the time served records, but if he was in jail only on this case and there was no other case or out-of-county hold or anything like that taking up that time, that he would be entitled to all his prior credit in this case, whatever that is, as well as the current jail time. So it would be revoke and terminate supervision, 12.1 months DOC with credit for all time served as determined by the jail. And if he has any questions on that after the jail provides the time served letter, he can let me know. $100 VOP fee, $150 public defender fee, outstanding monetary obligations to judgment, 24 months after release, Your Honor. May I approach you?
You may. State in agreement?
Yes, Your Honor.
Okay. Mr. Lee, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. So you heard your attorney state the terms of the plea agreement?
Yes, sir. 12.1.
Yes, sir. Okay, that's 12 months, 1 day.
Yes,
And, but you know, it has an effect that it go to DOC rather than the county.
Yes,
so you do understand that's what the agreement is.
Yes, sir.
And those are you will get credit for all time served, and it's important. Put your hand up.
Yes, sir.
It's important. I know Mr. Medina was explaining it. Just want to make sure you hear it from me.
Yes, sir.
We don't know what the credit. We don't know how much time the credit for time served. Whatever is calculated, just a different entity, which is the jail, calculates that. So there's no promises made. It's been X number of days, blah, blah. You understand that?
Yes.
You get credit for whatever you're legally allowed to have. And if you disagree with it, you can, but for today, you're resolving this case based upon this. Do you understand that?
Yes, sir.
Okay, and you believe it's in your best interest to enter into this plea agreement?
Yes.
I see you've signed the plea and sentencing agreement. Make sure you have you read it closely? Make sure you got all your questions answered by your attorney?
Yes, sir.
Believe it's in your best interest to enter into this plea?
Yes, sir.
And you do understand this will be a final resolution of your case?
Yes, sir.
So you'll be revoke and terminate supervision. That'll be done. Just do your time and you'll be able to get out.
Yes, sir.
Okay. Based upon that testimony here today, court will accept your plea, revoke and terminate supervision, sentence you to 12.1 months in the DOC Department of Corrections with credit for time served, with the fees and costs. They'll go to judgment 24 months after release, so you got 24 months to pay him after you get out before it goes to a judgment.
Yes,
okay. Any questions?
No, sir.
Thank you very much. Marcel. Marcel.
Yes, Your Honor. Mr. Underell, Sean Marcel, did I?
Actually, it's Alice Castillo.
Oh, this is Mr. Castillo, man. Okay.
Okay.
Sorry, Mr. Castillo.
Have to listen to you, right? Said you were bringing them out, man.
I know. Your Honor, Mr. Castillo's here on a felony violation of probation. At this point in time, what we need to do is deny the VOP. We're trying to get his Cordova records, Cordova Counseling Center records from Pensacola. If what my understanding from him is accurate, this may drastically affect his ability to successfully negotiate with the state. So it's definitely in his best interest that he get that. Our investigators sent that request. He signed an authorization for us to get those records. If we can prove he's done these classes and so forth, it's going to help a lot. So we don't have them back today. I hope we'll have them soon. Would the court permit a 1-week continuance on the VOP?
Sure.
So we can bring it back in a week?
Yeah, I got that information there.
I don't have to talk. You have the 20 years. Okay. Well, whatever it is they can give to our investigator, okay?
So we'll continue for 1 week till 17th, which is next Tuesday at 9 a.m.
Okay, thank you.
Okay, thank you.
You're going to come back with, you want me to have this? All right, very good. I'll look at it. Thank you.
Mr. Marcel?
State, I'm sorry, Mr.
Yes, Your Honor, this is Underell, do I pronounce that correctly? Underell, I'm sorry. E. Marcel, M-A-R-C-E-L-L, before the court in 21 CF 2190. He was originally scheduled to be before the court on a bond motion, but we have worked out a plea and sentence agreement that in essence was the same agreement that was on the table back in 2021. There was a failure to appear. Under this agreement, there would be an agreement not to file charges on the FTA. Basically, he had a very sad death of one of his children in New Orleans, and there were problems with the hurricane damage to their place of where they lived, as well as the car. So under this agreement, there would be a withhold of adjudication, 24 months probation that would be concurrent between 2 third-degree felony counts that are being pled out as charged. He would be waiving costs of supervision. This agreement would require or call for waiving of the cost of supervision because of the family situation. There would be $1,140 in court costs. There would be $150 public defender fees. He would have to forfeit the firearm. And I would note the reason he was over here in the beginning was because of a hurricane evacuation. So basically the firearm was part of the house taking its belongings with them to get away from that situation. But that firearm would be forfeited. He would have to do a substance abuse evaluation within 30 days and any recommended treatment to commence within 60 days. And I would note this was basically some cannabis that he allegedly had in his possession, so that's going to be resolved. It would be random urinalysis, no file on the FTA, and he may serve his probation in Louisiana. And he's going to initial that where I've written no file on FTA, may serve probation in Louisiana. Do you mind just initialing right here? I think everybody signed it, Your Honor. I need to make sure. Yes. Just to state in the score sheet. Yes. Thank you. And I do want to make it clear, I've explained to him that with respect to an out-of-state transfer, that he'll have to go through the interstate compact, he'll have to pay some money with the application.
Always more money.
Right. So for them to even process the application, he has to pay, is it $100?
Yeah.
And he may end up taking a while before it gets approved. That he can ask probation to consider if he can substantiate his residence in New Orleans. They may or may not approve a travel permit while the application's pending. I don't know what the outcome would be. He might be stuck in Florida for the next 2 years, but he has a family in New Orleans. He has
a job in New Orleans and so forth, but he does want to.
They're generally expedite, I mean, those generally go fairly quickly as long as the other state responds.
We don't submit paperwork until he pays the $100.
Well, okay.
But yes,
I got it.
typically goes very quickly.
Once he pays the $100, I'm just letting him know, it generally moves pretty quickly, right?
Yes, sir.
Okay.
May I touch on?
Yes. So I'm just want to try and give you a little bit of hope so that you can get to, I know Strand over here and everybody else is over there in New Orleans and your house and your family, you know, probably better to get over there just for a lot of reasons. So I just need to ask you a few questions and make sure that you understand what you're doing and make sure it's free and voluntary. So raise your right hand. Do you swear or affirm? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea and sentencing agreement that I see is contained in the actual written agreement that you signed.
Yes, sir.
Have you gone over this in detail with your attorney to make sure you understand all the legal ramifications?
Yes, sir.
You understand the big thing is by entering into this plea agreement, you're agreeing to waive the right to go to a trial and some valuable legal rights you're waiving. And not the least of which is to confront witnesses and go to trial and fight this thing. You understand this will be a final resolution of this case?
Yes, sir.
Okay. And you believe that's in your best interest to do so?
Yes, sir.
Nobody threatened or coerced you to get you to enter into this plea?
No, sir.
Okay. Based upon that testimony, the court will accept the plea agreement, states an agreement.
Yes, Your Honor.
There'll be a withhold of adjudication, which is significant. 24 months probation on each count. They'll both be concurrent, they'll run at the same time. Waive the cost of supervision, and then you've got court costs. Why is the court cost so? It's because there's a firearm involved? Why is the court cost so?
I think it's because of the firearm. Does the clerk have do we have the amount too high? We'd love to have
$11.40. It's what?
The marijuana charge.
Oh, because it's so high, the amount?
Because of the amount, I think it was like 84 grams or something like that. Something like that.
Your Honor, selling, manufacture, delivery, and trafficking have like an $1,100 or yeah,
Okay.
like an $1,100 court cost.
And obviously, forfeit the firearm, substance abuse evaluation within 30 days. Can he do that over in Louisiana?
Yes, Your Honor. My understanding is that they have adequate facilities to provide substance abuse evaluation and treatment.
Okay. I'm going to bring something up here, and I just want to try and get it resolved. Look, and I'm saying this because I want you to be successful. I don't want you to get tripped up on some technicality. I see a potential snag here. He's trying to get back to Louisiana. But it says here he's got the standard provision, got to apply within 30 days for substance abuse and follow up on any recommended treatment in 60 days, which means he's going to be stuck here.
Good point.
Can we say within 30 days after him returning to Louisiana, but we're not guaranteeing that he is returning? I don't know how to word it, but I don't want him to be tripped up on technicality.
Your Honor, one thing that he could do is, I know basically back in COVID days, oftentimes we were changing those time frames from 30 and 60 to 60 and 90. So I would suggest if the state doesn't object, we could change it to 60 for the evaluation, and that would give him time, if there is a snag in the transfer, to get with me. I could bring him in for a status, and hope maybe we can work something out if there's an inability.
Oh, I agree.
State doesn't object.
You agree? Yes. Your government.
Thank you, Your Honor.
Just put that in.
So we're gonna
just change it from, you got to do it within 60 days and then start treatment within 90.
Thank you, Your Honor. And he's going to initial by the 6 and the 9. Just,
You're okay with the score sheet, Mr. Medina?
Yes, Your Honor.
Thank you. Sorry. Okay. So, 24 months probation on both charges, concurrent. Cost, 60 days to substance abuse evaluation, 90 days to start treatment. Okay, any questions regarding that?
Your Honor, I am handing him from probation the initial reporting instructions, including the address, 13 Kelly Avenue, Wall Beach, where you need to report as soon as you get out of jail today. If for some reason you don't get out of jail today, you need to report at 8 a.m. tomorrow morning. Okay? And make sure you've got the $100 to get the application going on the interstate compact.
Right this way, sir.
Thank you.
Okay, thank you.
Good luck.
Darren Potts.
Mr. Marcel, did you have the $100? You can bring it tomorrow and we can process that.
Your Honor, Mr. Darren Allen Potts is before the court in 14 CF 1480. The state's given him its position on resolving the VOP. I think he's been before the court and with a denial entered previously, but we probably just need to come back in a week to give him some time to think it over, the two options that the state has given him. It's always possible that he'll want to have this set for a VOP evidentiary or that the state will, but it's also quite possible it'll get resolved in a week.
Okay.
Give him some time to...
We'll continue it to the 17th, which is a week from today, 9 a.m., and then we'll figure out you need a plea or we can set it for a hearing, whatever you want to do.
Thank you, Your Honor.
Okay, thank you very much.
Your Honor, Mrs. Hanshaw showed up. You had ordered a warrant or a take into
Hanshaw, would you come forward?
Yeah, we need credit for that on service.
We can't tell you
So
what
this
that
is case number 2020 CF 1885.
I can't tell you what the time served is.
Did you get the time mixed up, man?
No, I actually had a car trouble. I'm going through a homeless situation, and my son sleeps in my sister's couch in Pensacola, and he still goes to Choctaw High School. When I got to Pensacola to pick him up, I had a piece of metal shard in the tire, and I ran out of gas in the way here on Martin Luther King.
Okay. Well, I hate for that to happen, but you had to take this here. Somebody's going to come and pick you up. So this is, you have a violation of probation, ma'am. You don't have an attorney yet. You do have a right to an attorney. Do you wish to have an attorney appointed? Okay.
Your Honor, I'm sorry to interrupt.
That's all right.
Ms. Hanshaw, it is alleged that she has violated probation by virtue of the failure to make payment for court costs and a failure to complete 24 community service hours. If Ms. Hanshaw were to complete those two terms by our next court date, the state's recommendation would be a successful termination of probation.
Okay. So let me ask you this, ma'am. How long do you think you can do those two things, pay those fees, and do the community service? How long would it take you to do that? Can you do it in 30 days?
This morning.
I'm sorry?
I paid all the fees this morning, rest of it.
What about the community? Can you do the community service hours in the next month?
Yes.
Okay, so what I'm going to do is I'm going to continue this hearing until February 21st. Okay? And if on February 21st, I'm not going to appoint you an attorney because that'll cost you extra money. you get those community service hours done by the 21st, get them all squared away, this will be dismissed on the 21st, your violation of probation. You understand that? I'm going to withdraw the capias from this morning for you not appearing. Okay? So get those community service, stay in good contact. You've already been, you know who your probation officer is, so you know where to go with it.
Yes.
Do you have any questions?
No.
Okay, you can get this done. Just knock it out, okay? Take one day at a time. They'll work with you on these community service hours, but you gotta get them done. Okay, get them done. Hey, don't wait till the last minute. Get them done in the next couple of weeks, and then you don't have to worry about it. Okay?
Thank you.
Thank you, ma'am. Do we have anything else for this morning? Thank you, guys. Larry Patterson, what number is that in the doc? Who's the attorney? I'm sorry?
That's one of mine, Your Honor. Your Honor, Larry Patterson is a person who this court let out on a signature bond when he had his prior court appearance. I don't have any information as to his...
I don't have Patterson.
Larry Jermaine Patterson, 21 CF 1949 on the docket.
It's not on the, he has on the printout as being on.
Okay, I'm sorry. Go ahead.
I don't have any information as to his...
What is today's hearing?
It was basically, he had run out on his time for probation. The court, back with Judge Polson, and again with Your Honor, was really hesitant to lower the boom on jail in a situation with time served and he had to do some community control and pay some costs. And the court was giving him a signature bond to get it all cleared up, and he's not here today.
What's the underlying charge?
It was just a paraphernalia.
DOP sentencing today? I don't have it on mine.
It's basically when the court had him before the court on a plea to the bench on November 22nd, the court was inclined to reinstate his probation and not execute the 9-month suspended sentence that had been imposed by Judge Polson on September 13th, giving him a chance to pay his fees and do community service. And he's not here as the only thing I can report to the court.
Steve?
Your Honor, I think this is my case. I think that we were trying to, I think we set the sentencing off to give him time to complete this and told him he needed to come today. So I think I'm going to have to ask for a failure for a KPS.
So what did he have left?
It was reduced to basically be a $250 fee that was imposed by Judge Polson on September 13 for a $100 DOP fee and $150 public defender fees for a total of $250. And then he was supposed to do 24 hours community service. That was as of September 13. He apparently went back to jail and came before the court again on November 22nd. And the court gave him a signature bond, said don't use alcohol and don't use any non-prescribed drugs, and come back on January 10th, 2023. And that giving him time to complete those two requirements.
Probation have any up to, has probation been involved with him at all since this time? I mean, has he been working with community service hours, paid any fees?
Your Honor, I don't have anything in my record. I do see on his violation report that he did
substances in October, and then we have that he didn't complete treatment either.
So that's why he got picked up, but it had been reduced to those 2 terms required in order to more or less deal with the probation violation. Your Honor, I mean, I'm just throwing out, if we had any way to reach him in Georgia, we don't have a good contact number, but I could get with my investigator, you know.
He's in Georgia?
He is in Georgia. He went, my understanding is he would have gone home to Georgia. So if the court was inclined to give us a week to reach out to him, we'll get with our investigator, see if we can hunt him down and get him here on January 17th.
Ms. Sharpless, you going to give him a week to try and hunt this man down?
I'll
Apparently
agree
not
1 week,
cooperating
Judge.
whatsoever. What?
I'll agree to 1 week, Judge.
Okay.
And our office is, you know, the only address, the only contact information we had was a phone number through rest papers that apparently isn't working.
We'll continue it. What is the case number again? Make sure
It's 21 CF 1949. You know, I've argued that I thought 9 months was 9 months suspended sentence was harsh.
We're not dealing with it.
Right.
Let's just see where we got it. Come back.
Yes, Judge.
Figure out where we're at.
Thank you.
Okay, so we will at least have an hour. Is 1:30 sufficient? Is that enough time for you all?
Yes, Your Honor.
Okay. So we'll come back with our plea agreements, not plea agreements, with our arraignments. I'm sure there'll be some plea agreements.
And Your Honor, on this afternoon's docket, I believe it's 2 or 2:30, we had Mr. Chirenzia set for motion to suppress with Mr. Reed. I believe he did file a notice of cancellation, but I want to be sure of that so the court knew that for planning purposes.
Thank you. Madam Clerk?
And we discussed it and had no objection to it. Yes, sir. That was on the last docket.
Yeah, it's number 1 on the docket. I was reviewing it and it was like the docket's kind of.
Okay, I just wanted to be sure that because the docket that I still had it.
Okay, thank you, Madam Clerk. Thank you for, I wasn't really clear, quite frankly, on that. Okay, anything else on this afternoon's docket? I know we've got a couple other. So we've got William Lucas, an evidentiary, VOP evidentiary, is that?
Yes, Judge. He's an inmate. He will be here. I'm hoping that based on a discussion that Ms. Sharpless and I had, that we will be able to reach an agreement this afternoon. Otherwise, my assumption is the state will be moving to continue it because of the inavailability of a probation officer witness.
That's correct, Judge.
What about Mr. Bryant?
That is a bond motion, Your Honor, and
several motions. There's also a motion.
The motion to dismiss was not on the docket until February because the state had to potentially had to get with law enforcement on the motion to dismiss for untimeliness.
So is the bond motion still on?
Yes, Judge.
Okay.
And because it might take more than a minute on the bond motion, it was set on the specific
all
calendar.
Your Honor, I'm expecting the deceased victim's family to be here, just so the court's aware.
That's fine. We've got a little time. So you don't expect the Lucas case to proceed?
I'm optimistic there will be a resolution for a
okay. That's fine.
But it's ultimately Mr. Lucas's decision on whether to take it.
Okay, that's fine. But Chirenzia is canceled, so that's good. That's good clarification. Okay, so we'll see everybody 1:30. Any clerk? Okay, thank you. Okay, sure.
I guess